please rise. Judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals held in and for the state of New York may now draw near, give their attendance, and they will be heard. Please be seated.
Good afternoon, everyone. The first case on today's calendar is Welchuk v. Societe Generale. Counsel?
Good afternoon. May it please the court. My name is Michael Radine, speaking on behalf of plaintiffs' appellants. I'd like to reserve 3 minutes for rebuttal.
Yes, sir.
The Second Circuit asked if, under New York law, a predecessor's jurisdictional status is inherited when the successor assumes all of the predecessor's assets and liabilities. The great weight of persuasive authority, as the Fourth Circuit put it, says it does, and it should here too. As the Second Circuit noted, jurisdictional status is clearly inherited in cases of merger, de facto merger, and mere continuations on the one hand, but not in cases of simple asset acquisitions on the other. It then posited that the scenario before us today, where the defendant acquired all the assets and liabilities of the tortfeasor, appears to fall into the, quote, cloudy middle ground between those ends of the continuum. We submit that the question, therefore, is what meaningfully distinguishes a merger, de facto merger, and mere continuation.
Well, but why isn't just a form selection clause resolve all of that? I'm over here, sorry.
Oh, sorry.
Sorry, counsel.
A form selection
Right,
clause.
parties have foreign selection clauses, why not just resolve the issue that way? That would be an express statement of what the parties want to do and what they intend moving forward.
Well, of course, the plaintiffs have no control over the contract between the parties. They're
That is
essentially-
true, but this is about the intent of the party that's assuming the liabilities, right?
While that would be a clear expression, the acquisition of all the liabilities, where those liabilities include claims that are cited in New York, should also be clear enough. As courts have pointed out, corporations in
But would there
purchasing
be a
each other.
difference between existing claims and ones that don't exist yet?
No, I don't think there is. I think that both existing claims and claims that don't exist yet, in the sense that they haven't been brought yet, they have accrued, but they have not been brought yet, there wouldn't be a difference. It is certainly eminently foreseeable that those claims could be brought in New
And
York.
do you need both the acquisition of all assets and all liabilities, or just the liabilities? What's sufficient?
Well, of course, the question is under all assets and all liabilities, but
We understand, but I'm asking you, suppose it was just all liabilities.
sure. Well, the great weight, persuasive authority the Fourth Circuit referenced was referring to not only just liabilities, but just the liability in question. So here, for example, tort liabilities. But what happens when a corporation takes all assets and all liabilities is that it essentially takes all the value of the corporation that is hailable in the jurisdiction and removes it, along with the liabilities that would offset those assets. So the result is something that's eminently unfair to creditors and plaintiffs.
Well, so you could think of an insurer as somebody who has assumed liabilities under certain circumstances. So would your rule be sufficient to render foreign insurers liable here directly?
Well, if they've acquired all liabilities, then they would be liable. The question is would they then be hailed into
Yes.
the jurisdiction?
jurisdictional,
Presumably,
yes.
they have acquired those liabilities in order to defend them, as opposed to remove them from the jurisdiction. But if the question is whether
could you sue them directly here, or would you need to sue the insured party?
for that liability, well, the insured party there, of course, would, under that insurance policy, has the power to gain indemnification.
Sure.
When all the assets are taken, the
Would that
corporation.
be a fair reading of the liabilities transfer here?
Well, sorry, Your Honor.
Let me ask it a different way. LCB continued to exist, correct?
Nominally. All it does is defend
Well,
this lawsuit.
Okay, but it received several hundred millions of dollars, right?
It received $580 million, most of
it's-
which were
and it's
all
corporate-
gone.
Well, all gone now, but as of the moment of the asset and liability agreement, right, the execution of that agreement, LCB still existed. Yes?
Nominally, yes.
Well, it had, I mean, If I have $580 million, I think of myself as having a little more than a nominal existence, at least financially.
Well, leaving aside even the significant portion that was immediately seized by the United States before it even left escrow.
Okay, seized is frozen, that's not a determination, but okay, leave that aside for a minute.
Their liabilities, $580 million is a lot to you and me,
Yeah.
but to a corporation with the liabilities, the scope of LCBs, it's a pittance.
Well, I understand that, but I'm asking a more of a theoretical question, not that has to turn on how much money was left there. I mean, if you suppose it had been $500 billion, more than enough to satisfy your judgment. My question is, could you have sued LCB here? There would still be jurisdiction over them, right?
Yes.
And if they had an insurer who was liable for that particular judgment, let's say, could you just sue that insurer here, even if it was a foreign insurer, without suing LCB?
Well, in that case, LCB, so I suppose, has all of its assets if it simply transferred its liabilities.
Yes.
And certainly under New York law, you could sue either the tortfeasor corporation or whoever's acquired its liabilities. As for the jurisdictional question, it seems that there may be less of a danger if there's been, if the assets haven't left the jurisdiction. And that's certainly the basis for other courts' holdings about de facto mergers or mere continuations, that the assets have left
Well,
the jurisdiction.
Would you still have the opportunity, or the court or the parties, to do a personal jurisdiction analysis based on the business the insurer has with an entity that has New York connections? I mean, I assume in part the Chief Judge's question is that if there was no other ground for personal jurisdiction against that insurer, I think that's in part what the question was, could they, based on your argument with respect to the company, also sue the insurer under that same theory? Because if you otherwise have personal jurisdiction under some other theory that's obvious and clear, and we're not going to talk about that now, can you use this theory against an insurer? Because they've insured the party.
Right. I don't know that the plaintiffs, the needs of the plaintiff are implicated where an entity has simply offloaded its liabilities but not its assets.
And
Does
why,
not seem,
why are the needs of the plaintiff the only relevant touchstone we should look at? I mean, if you look, for example, at our decision in Seminets, which I realize is a liability decision and not a
Right.
jurisdiction decision, it suggests that appreciating or accounting for the impact of a rule on businesses is something that should also be taken into account.
yes, and as the Second Circuit said, the expectations here on the corporation are having purchased liabilities, that it knew what they were. It didn't have to.
So is your view, I mean, presumably, we're talking at least about, a rule that would apply to the purchase of all assets and liabilities, not specifically the parties to this case, right?
Correct.
And so if that's the case, is it your view that that expectation is different in kind and a lot more robust than if you're simply buying a product line?
Yes, yeah. The
And
product,
why is that?
because there's not the concern with the product line rule necessarily that there's an incentive to remove assets out of the jurisdiction, and perhaps to evade a litigation just like this one. The basis for our argument here is the same as the one for the underlies de facto merger, mere continuation mergers, the other scenarios in which the courts here already find that that personal jurisdiction is, that status is inherited to the buyer.
So that seems to me to be about the question of the incentives that we're setting up. But to go back, if we can, to the fairness point for a second and your exchange with the Chief Judge. So if there's $500 million in assets that LCB has, and I understand you're saying only for a short period of time, but how do the fairness concerns play out there if you have plaintiffs who presumably could file as against that $500 million?
I think that the issue is not that it left no cash behind, if you will, but that the cash is insufficient for the liabilities that they purchased. They bought a company that had $6 billion in assets and paid $580 million
But that's not going to be
for it.
true in every case, right? I mean, and that's why I said, it seems to me the level of generality that we're looking at is what's the rule with respect to the purchase of all assets and liabilities, not specifically with respect to the financial circumstances that the parties here have, right?
Yes, Your Honor, but the rule is preventative, as in the rule does not, as in so many rules that seek to deter or prevent unfairness to a party or a fraud on the court or on the party. The rule doesn't only kick in after it's shown to have been needed. The statute of frauds is true whether or not the oral the oral contract was valid or not. The idea is that the rule prevents.
You might have a rule that kicks in when it's needed, which would be something like, if you showed that the transfer was for the purpose of avoiding jurisdiction, then there's jurisdiction.
Well, I think that it certainly should be included in the rule in the sense that it would cover that situation as well. But I don't know that the intent necessarily matters.
Well, no? I mean, it seems to me that in a lot of the cases, the concern that's expressed is not allowing parties to set up corporate entities elsewhere for the purpose of avoiding jurisdiction and avoiding the liability that would be easy to satisfy if you had jurisdiction and very difficult without it. And that could be accomplished by a different sort of rule. And so when you were mentioning the difference between $580 million and $6 billion, that's what struck me, is that you're really kind of arguing for a rule like that.
Well, it seems that instead of trying to make that determination in every case, just as that we don't ask for in other situations of inherited jurisdiction, whether there's an insurance policy or indemnification that could cover plaintiffs. We simply have a rule saying we're not going to allow a buyer corporation to take the assets and liabilities out of the jurisdiction without being at least hailable here. Of course, there's no question that the buyer is liable in these scenarios. So that they already face. The only question is whether they have to defend it here or there. And the argument we're making is that in this situation, it's fair to have them defend the case here in New York where they purchase liabilities that include.
Why couldn't you have pursued the case, maybe you still are, against LCP to judgment, gotten a judgment of whatever amount, and then tried to enforce that using the assumption of liabilities provision?
You mean enforce it in Lebanon,
Yeah.
where SGBL
Yeah.
is. So I see my time's expired. Let's answer Your Honor's question. I think that it's in New York's interest to provide enforceable judgments. I think that judgment enforcement is much easier where the court has jurisdiction over the judgment debtor itself for a variety of reasons, whether it's for discovery or for seizure or for other practices that assist in that process. This court said in Grant Howard that the Schumacher forms of acquiring liabilities are, quote, consistent with the desire to ensure that a source remains to pay for the victim's injuries. And I think that means a source that this court has control over and can make demands of rather than sending plaintiffs out to try their luck abroad.
Chief, may I ask one last
course.
question? You say at footnote 7 of your brief that SGBL made claims in the Southern District. But you're not arguing, I take it, that they purposefully availed themselves here and therefore, satisfy 302 on their own terms. Is there a reason that you aren't making that argument, or maybe I'm missing something? How does that play into our analysis of successor jurisdiction?
We highlight that to, well, I'll say the reason why we don't rely on that is that's not the Second Circuit's question, is whether SGBL's own conduct
Yes.
also.
But did you litigate that in the federal court?
Was that
Rely on
raised
that in the federal court?
to the Second Circuit?
No, in the district court.
Oh, the district court, I don't believe so. We raise it simply to make the point that the jurisdiction is one that, for the same monies as in the purchase money, that the buyer will come here to take advantage of the jurisdiction to make sure it retains, but then argues that any monies it has are outside of this court's or courts of New York's jurisdiction when the plaintiffs come and seek them. Thank you, Your Honor.
Thank you.
Good afternoon. May it please the court, my name is Brian Lesky. I represent SGBL in this matter. An out-of-state asset and liability purchaser does not inherit the jurisdictional status of its predecessor under New York law for 3 reasons. First, it is black-letter law that there must be a statutory basis for personal jurisdiction, and it must be applied to each defendant to a case. Here, CPLR 3021A authorizes jurisdiction over an out-of-state corporation based on its own conduct within the forum or that of its agent.
But does it apply to successor jurisdiction in an instance like this?
It does, Your Honor. Plaintiffs have made the argument that the long-arm statute only has to be applied to the predecessor, but there's no basis for that conclusion. Each defendant, due process has to be satisfied with regard to each defendant to a lawsuit. And if a lawsuit involved two tortfeasors where the claim was made against both of them, the court would apply the long-arm statute to both of them.
But wouldn't that make, I was going to say, wouldn't that make successor jurisdiction irrelevant, essentially? I mean, if you have to show that the party independently satisfies 302 without regard to whether the predecessor satisfies 302, then you're not really inheriting or imputing anything, are you?
Well, I think you are, and I think the way to look at it is this. The courts that have considered a successor liability theory have found that it's not the fact of liability that's important, it's the basis for successor liability. And virtually all those courts that have looked at that issue have found that where the predecessor and the successor are one and the same, meaning where a plaintiff has alleged plausible facts of alter ego, of merger, of de facto merger, of a mere...
But the question here is whether to go further.
The question...
Nobody's debating
Yeah.
what you've just described.
Yeah.
Everyone acknowledges those exceptions.
Yeah, so I don't think...
Why
there-
not go further here,
So I don't
given
think...
accepting all assets and all liabilities?
I understand. I think the analytical point here is that the entities are the same. So the contacts of the predecessor are the contacts of the successor. And you're just going ahead, actually, and applying the long-arm statute or applying a due process analysis. So that's where the successor liability comes in here.
Well, that
To your-
to me seems maybe a bit tautological, right? I think the question, as Judge Rivera says, is should we also do that when there is a purchase of all assets and liabilities, understanding that we, in other jurisdictions have, at least other jurisdictions have done it with respect to a merger, whether actual or de facto.
Yeah. Well, two answers to that. First, obviously, the text of the long-arm statute itself, when you apply it, makes no reference to successors and only imputes contacts, which is really what you're doing.
But the long-arm statute then wouldn't really even allow you to reach a merged entity, right?
Well, this court has not reached the issue. The Second Circuit certainly has weighed in, and again, the
Well,
analysis...
no, I guess what I'm saying is you seem to be saying if this had been a merger, there would be jurisdiction. Because it wasn't, there isn't.
Yeah,
So far, you with me so far?
I am with you this far.
Okay, but I don't then understand how, under your statutory argument, a merger would fit into this if it's a New York corporation that's merged into a Delaware corporation.
So the analysis that has been adopted is that only one entity survive a merger. And both the predecessor and the successor survive in that entity. So you're back again to the analysis that those entities are one and the same. So the jurisdictional context of the predecessor are the jurisdictional context of the
So
successor.
does that require...
And that's not the... Oh.
And that requires the predecessor no longer exists in any form.
Well, a merger is normally
Right?
not an...
But that's what I
yes,
mean.
yes,
There's-
yeah.
There's now
That's right.
only one entity that
One
remains.
surviving entity in that situation, and it's not an all-cash transaction like an asset and liability purchase. And I think this is what the court is looking for. The difference between the scenarios of de facto merger, a corporate reorganization, a merger, and an all-cash asset and liability purchaser is threefold. First, there are two legal entities involved here.
So, just, I interrupt you, but understand that. But does it matter the basis for long-arm jurisdiction that's asserted? Because and again, maybe going back to something the Chief Judge said early on, which is you bought assets and liabilities, the company, and the basis for jurisdiction here is A1, doing business, and the doing business that we found gave long-arm jurisdiction was the corresponding accounts in New York. That money was going through. So you bought assets, you bought liabilities, you bought that business. Presumably, you bought that asset with the goodwill that comes with it from doing business in New York. Why don't you buy this too?
Yeah. Well, if we're talking, this lawsuit was not filed till well after. If a company used assets that were purchased then there's going to be jurisdiction.
Yeah, but you bought those assets. You bought presumably the ability to do that business here, corresponding accounts, right?
But, and if the claim arose from those assets, this claim did not arise from the purchase of those assets. It happened 9 years later. And Greenberg is a very good example of that, where a New York company, where the owners of the company dissolved the company and took it to Canada. And this court looked at it, and it didn't find that it was a successorship and that therefore there was jurisdiction. It found that it was that the Canadian company, the reincarnated version, was doing business. And it hinged its analysis on the long-arm statute. It just didn't simply jump ahead and say successor, predecessor, there's going to be jurisdiction. But the two other reasons why an asset and liability purchaser is different is that two companies survive the transaction and go ahead and do their own thing. And the third thing, which is probably most important, and that's clear on the record here, is that there's no continuity of ownership of the predecessor in the successor. So you have two separate companies doing their own thing with no
So
ownership
two
interest.
separate companies doing their own thing.
Which means the jurisdictional
The predecessor
contacts are
exists in
different.
some form, right? So they would have, the court would have jurisdiction over that predecessor. Am I correct?
Absolutely
I'm
would have
following this
jurisdiction
argument
over the
so far.
predecessor.
Okay. And then your position is, so then they should sue that predecessor? Am I
Absolutely.
Following you? Okay. The predecessor has entered this agreement where someone else holds the liability, so the predecessor would what,
Certainly could
bring them in
bring-
as a third party?
LCB could have brought, if they thought that SGBL was responsible for the tort,
Yes.
they certainly, well, they had every opportunity and would have brought SGBL in. And plaintiffs could have, at that time, brought them in also. The key thing here, though, is that New York law already has ample tools to handle these problematic situations.
Could
None of
there
which-
ever be personal jurisdiction in an instance where all of the assets and all of the liabilities are bought?
I think, again, if the analysis that the courts have used, and this is even in the North Carolina decision, is that when, and the patent decision out of the Fifth Circuit is when the entities are one and the same, they are. And a merged entity is essential,
So one needs to disappear, so to speak?
one needs to disappear, or courts have also found where the predecessor actually has an ownership interest in the successor and is just merely abusing the corporate form or is trying to secret assets out of.
But there
out of-
is there not in the courts already an exception for fraud, which is closer to what the Chief Judge was asking your opponent about before?
Absolutely. The New York tools that already, the tools in New York that already exist are alter ego. If the two are one and the same, then the jurisdictional contacts are going to be the same. If there's fraud on the court
They fall short of alter ego, it's clearly done for some fraudulent purpose.
or a fraudulent purpose, that was actually
my
presented
point.
in the North
That was my
Carolina
point.
case.
So then you'd have the trial on the fraudulent purpose, and if you find the fraudulent purpose, if that's the finding of the court,
I would accept.
then you would say personal
Then
jurisdiction
I
is
think there would be
appropriate?
personal jurisdiction
And
because.
what theoretically is the reason for that?
Well, courts have always had an inherent power to exercise their, if a company or if a bad actor is trying to avoid jurisdiction. And at least this court's opinions have held that that's actually a fraud on New York. And therefore, that represents some personal activities under the long-arm statute that would allow you to reach a company in that situation. But none of the unfairness concerns are presented with an asset and liability purchaser. SGBL had no connection to any of the tax. There's no ownership interest. It's not a corporate reorganization of LCB.
Well, did they plead that? Did they plead it was fraudulent? That's another reason
They didn't
to
call-
exercise personal jurisdiction, putting aside the merits of the claim, not before.
Most of the arguments that we're hearing today and your questions are really not even presented by this case because the plaintiffs have never argued that the long-arm statute applied. They've never argued personal availment, that SGBL did anything. They haven't argued merger. They haven't
So
argued.
it sounds like under your recommended rule, they can, if the predecessor exists, they can sue the predecessor at the time they want to bring the lawsuit. They can sue the predecessor in New York because the predecessor we
Or
would have
afterwards,
personal
yes.
jurisdiction over
Yeah,
them.
absolutely.
And/or sue the entity that assumed the liabilities, wherever they can
Wherever
get
they can be
personal jurisdiction over them.
Wherever they can be
Correct?
found. And the Simmons court actually made that crystal clear. And this court has consistently found in Feathers and in a host of other cases that liability and jurisdiction are two different concepts. And the question
You
of
move to consolidate those cases once you do that?
You probably could. You could either bring them, you could sue the two entities together, you could bring it separately. But this court has consistently recognized that liability and jurisdiction are different, and you have to decide the jurisdictional question before you even think about the
Can
liability
we
question.
go back to the fairness question
Sure.
for a minute? So if I'm understanding the timing correct, and correct me if I have it wrong, so the attacks at issue were in 2006, and I believe there was a separate action, but based on some similar theories, filed against LCB in 2008, is that right?
That's right.
And then in 2011, the Treasury Department designated LCB a primary money laundering concern, and then this deal took place a couple months after that,
Yep.
right? And so I would expect that, especially as sophisticated a player as your client, would have considered those liabilities and priced them into the deal. So help me understand how the fairness concerns play out here.
Yeah, the plaintiff's argument has been that somehow that you can unmoor the liabilities and the jurisdiction, and that's not so. As we know, you can sue LCB and you can get that, the $600 million, which is far more than what they've, asked for here. And a company, the expectations of SGBL is not the same as the personal jurisdiction analysis that this court has to make under 301. It's not a foreseeability analysis. Purposeful availment and foreseeability are two different things, and even
So that seems like it's a ex ante, ex post question, right? In other words, would it be the case that if we were to have a rule that applied prospectively so that anyone in the market that was going to look to do a purchase of all assets and liabilities would take that into account, it would be different? Is it a notice proposition or
Yeah,
something else?
It's a very difficult rule because it would represent really a sea change in asset and liability purchases and in jurisdictional law because.
Well, I'm not sure the court has pronounced on it yet, so
Yeah.
I don't know if it would
No,
represent a sea
yeah.
change. But
Plaintiff's theory, taken to its logical conclusion, means anytime there's liability of a company, there's personal jurisdiction.
Well,
That's,
could you write into the agreement that the party does not waive any personal jurisdiction challenges it may have?
yeah, I mean, the parties, the two contracting parties are free to come to any agreement that they have. We're here,
I'm saying if we agree with them, would it be possible for the parties to say, or the party to negotiate, I don't want to fall under that rule, I want to avoid that rule, and so I don't waive, right?
Yeah.
You'd make your decision if there was a lawsuit at the time, whether or not it's beneficial to your client, to nevertheless subject yourself to personal jurisdiction in New York, right?
Yeah, parties are free to contract and limit their liabilities and limit the assets, obviously. Here, we're here on a motion to dismiss, where plaintiff's allegations have to be taken as true, and they alleged that SGBL assumed all the liabilities and all the assets. And we don't have an opportunity to contest that at the motion to dismiss stage. So
but
that's
let me-
where we
if-
are
if-
now.
If I may, just to clarify your responses to Judge Halligan, if I'm understanding you correct, it may be a crude way of putting it, but it seems to me what you're saying is that when you negotiated the price, you negotiated, we may be liable for X, Y, and Z, and that'll be this amount, but you weren't negotiating, and wherever we've got to defend that liability, that'll always be New York, or that will include New York. You're saying that wasn't part of the price point.
Yeah, that wasn't, it's not in the record of what
You're
the
focused on the
agreement
liability
says.
itself, not
Yeah.
the form.
Plaintiff's theory is purely that a liability equals jurisdiction, and as I said, our position.
No, I'm saying that in response to Judge Halligan, I think she was getting to this point, and as they argued in their brief, you're already factoring that into the price. And you're saying, no, that's not being factored into the price, if I'm understanding you.
I think that's right. I mean, I think this is, this is a corporate transaction. You can't affect the rights of a third party against you. You can react against, you can insure against, you
No,
can.
but you surely can negotiate with respect to the scope of liabilities that you're assuming, right?
Certainly. And that's why
So if you
LCB.
want to carve something out, you can certainly
You
do
can,
that.
absolutely, and if, again, if LCB thought SGBL was responsible for the liability, they certainly could have and would have brought them into the lawsuit. And I know you asked one question about the Southern District, and I see my time is up, if I may.
Please go ahead.
There was some monies that were held, frozen by the Justice Department involving the transaction, and SGBL came in and filed as an innocent owner in the asset to respond and make a claim in that asset forfeiture action. And in it, it expressly reserved all its rights to personal jurisdiction. It was not subjecting itself to jurisdiction in New York or otherwise. It was filing, as federal law allows you to do, a claim as an innocent owner. And what SGBL was saying is, in the process of
Without
the,
purposeful availment.
excuse me?
Without purposeful availment of the form.
Certainly, and it certainly doesn't arise from the suit, which is really what you need in conjunction. The activity has to be suit-related for purposes of specific jurisdiction. So not only did they reserve the right, but it certainly had nothing to do with, the lawsuit that was filed almost 10 years later. So,
Thank you.
thank you very much.
So as your honors heard, defendant's view is that what makes sense of their theory that you would apply the long-arm statute essentially twice to predecessor and then to successor is that they're the exact same entity. The entity is only moved and it no longer exists here. That's not true for, first of all, for all the forms of successor jurisdiction in New York, as the Eastern District held, but relying on First Department cases, and this is in a successor jurisdiction case. This is Gould v. ILKB. To the extent the successor defendants argue successor liability pursuant to a de facto merger requires ILKB's dissolution, New York law holds otherwise. So it's already not the case in de facto merger. Now, in a de facto merger, where you have a sort of defunct shell left in the jurisdiction, which is what we have here precisely,
Well, 580 million being defunct, okay.
well, the question is whether there's the LCB would implead SGBL to protect its assets. LCB is rendered defunct such that all of its creditors now are coming for that $580 million, whether the claims are already brought, as in the plaintiff's original suit against LCB, or those claims are yet to be sued upon.
But when you say they're a shell, what exactly do you mean, given the amount of money? I'm
Well,
not following.
LCB has no assets. The money was, it has no money. It represented to the United States Supreme Court that it has
So
no
where's
money
the
to pay a judgment.
$500+ million?
Well, the United States seized.
Frozen?
No, I don't know where it is as the plaintiff, but it's LCB who has represented the Supreme Court that they have no money. I don't know where it went. Some the United States took due to their wrongdoing. Some may have gone to other creditors. I don't know. They're in liquidation in Lebanon, so I imagine it's gone to creditors in Lebanon. But they have no incentive, and I think this even goes to the Chief Judge's question about insurance. They have no incentive to implead SGBL because they have no money to get back. They have no assets which could be seized. They effectively don't exist except as a shell corporation. So
I'm not
unlike,
so sure about that. It depends on what the liabilities that were assumed by SGBL are, right? I mean, they may have already paid out claims that are really liabilities. I don't know that, what the terms of that are exactly, but maybe some money they can get back.
that LCB could get back from SGBL.
Yeah, if LCB paid out claims that were subject to the assumption of liability in the contract, I assume they'd be entitled to recoup those.
Oh, claim monies that they've already paid
Yeah,
after, well, they
yeah.
entered liquidation and then were purchased by SGBL. So perhaps other creditors could do some sort of clawback action in Lebanon, I don't know. But here in New York, they have no incentive to implead, unlike an insured party, SGBL, because they have literally nothing to lose to plaintiffs.
So I'm curious about one thing in your complaint that may not amount to anything, but your complaint is filed long after the transaction in question, and yet it alleges that up to the present time, LCB is engaged in the various terrorist activities that you're complaining about. It seems as if you assumed even when you filed the complaint that they were still an ongoing business.
I believe, I don't have the site in front of me, I believe the complaint says that LCB,
It says, including the period between 2004 and the present day, LCB carried out the Hezbollah wire transfers and provided Hezbollah with other banking services.
oh, that period ends in 2011, because once the United States designated LCB, it lost the capacity to bank through New York correspondent banks. So it's alleged in the complaint certainly that it ceased banking operations as of 2011. I see that's my time.
Did you have one more point you wanted to make? I interrupted you.
I did, no, thank you, Your Honor. Just about liability and jurisdiction not traveling with each other, just to make clear, of course, acquiring a liability in the sense that if you are in California and you're a non-New Yorker, and you assault a New Yorker, you have liability to that New Yorker. But there's not jurisdiction over you in New York on those facts because all you have is liability. The issue here is the liabilities are liabilities that arose in New York under this court's 2012 Leachy decision. The liabilities are to claims in New York, including ones that existed already, brought, and ones that had already accrued. These liabilities accrued in 2006, but had yet to be brought. So to be clear, there's a difference between liability simpliciter and liabilities for claims that have a relationship to New York, in the sense that the jurisdiction already attaches there.
And then, I'm sorry, just to follow up, to be clear on the other point you're making with that. Therefore, when they negotiate this purchase, they understand that there are some liabilities, I don't know if they're all, but certainly the ones you're talking about, were incur in New York to the extent that the predecessor would have been subject to personal jurisdiction in New York. And so that's something that they understood at the time they entered their agreement. Is that in part what you're?
Sure. I mean, they already had, of course, the lawsuit that sort of precedes this one in New York. But knowing this full scope of Hezbollah's attacks on Americans, for example, and knowing that the Anti-Terrorism Act exists, then they would know not only about that suit, but any number of claims that would have accrued up until the purchase in 2011, as in there were injured in that time.
But then anticipate that the lawsuits would at least start in New York. Whether or not they can proceed in New York is another story, but that there would be people seeking to bring these claims in New York.
Right.
That's the link, okay.
Yes.
And to sort of take your last example and change it a little bit, a minor who is domiciled in California with the minor's parents comes to New York and injures a New York resident. Can the parents be sued in New York? They have legal liability for the minor.
Working this out. So the minor has come to New York. They have legal liability for that minor.
And the parents have never set foot in New York.
Right. I don't know. It's a good question. I mean, if the reason why the plaintiff, those are all good questions, right? It's your job. But if the issue of the liability is because that the minor is judgment proof, for example, then yes, it may be appropriate in that circumstance where, there's nothing else to be done for the plaintiff except chase the parents around the world.
Or they're the guardian and they're responsible because they allow the child to come to New York and they're responsible for conduct that happens in New York that may be a tort.
Yeah, certainly. Another possibility.
There you go.
Take it. All right. Thank you very much, Your Honors.
Very funny.
Next case on the calendar is Odthan v. Nick and Duke.
Good afternoon. May it please the court. Elon Dobbs for Odthan LLC. I'd like to request 5 minutes for rebuttal.
Sure.
I want to emphasize up front that the decision on appeal arises from a motion to dismiss, where the allegations in the complaint are presumed to be true and where my client Odthan was entitled to all reasonable inferences. The appellate division majority did not faithfully apply this standard. With this firmly in mind and in this procedural posture, the question before the court is whether landlord's June 2021 letter was a repudiation of the lease. And make no mistake, when the landlord said in June 2021, for the first time and in the future tense, that it will not and will never sign a cure
Does
agreement.
the court get to interpret what that letter meant or didn't mean?
To the extent the court can interpret what is not in the four corners of that letter, it must do so in a way that makes all inferences in favor of Audthan. And one of the things that happened,
So you're saying it was okay for the appellate division to interpret the letter at the 3211 stage?
not in the way it did. I believe that the appellate division said that in the letter, the landlord reiterated its previous reasons for refusing to sign a cure agreement in 2015. That's not so. The letter does not say that.
Couldn't the letter couldn't the letter, in fact, have more than one meaning and is up to a fact finder?
That may be the case. I don't believe, and this is the reason why our allegations about that letter are presumed to be true, and our allegations about that letter, or that landlord's statement, should be taken at face value, which is that it, according to it, at that moment, no
At
cure
least
was
at the
warranted.
stage, at the motion stage where you were.
Correct, at the motion stage where we were. And it may be that at a future time, at trial or at summary judgment, probably at trial where credibility determinations are at issue, what was really in the landlord's mind may be something for the trier of fact, the judge, to determine. And it was error for the appellate division to sort of make a whole host of inferences in landlord's favor about what it meant and what it was really had in mind when it wrote that letter in 2021.
Let me just
So
ask
are you
you,
saying-
sorry, go ahead.
I'm sorry, I just want to know whether your position is that the courts below couldn't look at what was happening in, I think it was 2015, when the landlord first said, that they didn't want to enter into the cure agreement as drafted, whether they weren't allowed to look at that and view that as the beginning of the breach that you're now complaining of.
Look, because it was a 3211 motion, the court is confined to the allegations of the complaint and the documentary evidence that was properly before it. And so, to the extent there are allegations in the complaint about what happened in 2015,
Yes.
as framed in the complaint, those well-pled allegations are entitled to the presumption of truth. To the extent that the court engaged in a bit of psychoanalysis about what was in the landlord's mind in 2021 when it wrote the letter vis-a-vis its previous conduct in 2015, that's a bridge too far.
I guess my issue, though, is this distinction between a breach and an anticipatory breach. The court is aware, because of the pleadings, of the 2015 activity, which they viewed as arguably a breach of the contract, and that what happened in 2021 is just a continuation of that same breach. Isn't that their line of reasoning to justify what they did here?
That is their line of reasoning, but it's not borne out by the facts that are pled in the complaint. In 2015, what the landlord did was my client tendered a cure agreement to the landlord. The landlord said, no, we're not going to sign this. Why are we not going to sign this? Because it provides for more affordable housing, more square footage of affordable housing than the lease requires a cure agreement to contain. And so therefore, the cure agreement that you gave us does not comply with the terms of the lease. In 2021, shortly after having been enjoined by Supreme Court from attempting to terminate the lease anymore, landlord embarked on a new path. It started writing letters to HPD, falsely accusing my client of committing fraud. And when HPD rebuffed its attempts to get it to rescind its blessing on that cure agreement that had been circulated in 2015, landlord wrote its June 2021 letter. And what it said in that letter is that no cure agreement was warranted, that it will never sign one.
So let me ask you this. Let me change this up a bit, and let me ask whether this is a possible reading of the agreement that you have. And I'm just looking at the contract itself. I don't worry about who said what afterwards, just the contract. You've got somebody who owns a piece of land. They don't really know how to maximize it, to develop it properly, and there's some regulatory issues around it. Your client knows how to develop the land and is going to put up a much bigger building, and the uncertainty is, what is HPD going to do? So you enter into an agreement that provides for a 40 and 48 years, so basically a 100-year lease, right? With the idea that you'll develop it if you can, and they'll turn it over to you for that period of time, and they'll get it back at the end of that. And what you agree to is that, given the uncertainty around what HPD might do, If either of you refuses to go forward with signing what's necessary, the only thing you can do is to try and compel specific performance. Damages are not available to you. Why is that not a reasonable interpretation of the contract?
Well, it's not a reasonable interpretation of the contract because the section that you're talking about, the damage limitation provision, section 3309, applies when a party has a right of approval or consent which may not be unreasonably withheld. Now, that's a concept that is very well worn in landlord-tenant law and in contract law generally. So well worn, in fact, that the parties used it 22 separate times in the lease. We listed those on page 22
Right,
of
and
our
but the
brief.
question is if it's unreasonably withheld. In fact, that provision itself says wrongfully, I think, right, which is even stronger, I think, than unreasonably, that your remedy is limited to specific performance.
But the parties used the language, the limitation applies specifically in instances where there is a requirement of approval or consent.
That's
and that be
wrongfully withheld.
Wrongfully withheld. Now, in section 14.01, which
Sorry, but isn't that what you're saying happened here? They wrongfully withheld their consent to sign the HP? They didn't?
It is not at all. In signing the agreement, the landlord agreed that a cure was necessary and that it would cooperate in executing the documents.
That some cure was necessary.
No, but it's more than that. It specifically says it provides what the contours of that agreement are going to be. A 58,000 square foot building that provides for approximately 15,000 square feet. This was by signing the lease.
I understand that's in the contract. So give me an example of how you would wrongfully refuse to sign that.
The contract, give you an example.
HPD comes up with a proposal. Maybe it's not 15,000 square feet, maybe it's 16.5, or maybe it's 14.1. Maybe neither of those is wrongful.
That's not the bargain that the parties struck. The bargain that the parties struck is if the cure agreement complies with what the lease says the cure agreement should be, which is that it contains approximately 15,000 and there's a mixed-use building,
then you have
to sign it.
And if you don't sign it, if you wrongfully refuse to sign it, you are limited to specific performance.
But that's not what the contract says.
Isn't it?
It does not. Because 22 separate times in the contract, but not in the obligation where the landlord must sign the cure agreement, section 14.01, it does not use the words, the landlord has the right and the discretion to consent to or approve of this. The landlord, by signing the lease, approved of a cure agreement that contained the following items. In other words, that it provided for approximately 15,000 square feet of affordable housing and a mixed-use building of 58,000 square feet. And the parties waived money damages in other instances where the lease requires consent or approval that shall not be wrongfully withheld.
That's those other 22 examples?
Yes, there are 22 examples, but not in section 14.01. And in those examples.
Then I don't understand what 3309 reads on.
3309 tracks a well-worn concept.
I understand. What obligation in the contract does that apply to?
It applies to the 22 separate instances that reference.
But not 1401.
But not 14.01 because the parties knew how to reference that concept. And the 22 instances are things that may arise in the future going forward over the course of this 88-year lease. What are they? They are approval of a lender, approval of a sublessor, whether or not there can be a leasehold mortgage on the property and under what circumstances. The cure and the contours of the cure, what it would entail, were pre-baked in, but also, and acknowledged. If you look at the language of section 14.01, the parties acknowledge that a cure is necessary.
Is the reason, just to focus on the language of 1401, so is the reason you say it's distinct from the other provision, is it that the words cooperate in good faith and in executing any documents, et cetera, I'm paraphrasing the last piece, that's materially different from the words used in 3309?
Yes, that's correct.
And so what's the remedy for a breach of 1401 under your theory then?
The remedy, all remedies available at common law for breach of that provision are available because to limit a common law remedy, like a right to damages, requires specific, directly on-point language.
If the parties wanted subject 1401, if you think that it, as drafted, it's not subject to 3309, what would they have needed to say differently in order to be clearer in your view that it was subject to 3309's restriction?
They would have, like they did elsewhere in the lease, tracked the language and said that when presented with a cure agreement, the landlord has the discretion to approve or disapprove so long as that approval is not unreasonably withheld.
Okay, so the words execute and cooperate in good faith and execute are materially distinct. You're-
Yes, they are. There's this obligation to cooperate in executing the agreements. And
So could you, I'm sorry, over here. Could you, I thought I understood in your brief that you made the argument that the injunctive relief is nonsensical because it's no relief at all for this particular type of breach. Or did I misunderstand the argument?
the argument is that if this was in fact a material breach that gave Odthan the right to terminate the agreement, and we believe that clearly was, that to the extent that Odthan was able to terminate the agreement and declare it at an end, a sole remedy of injunctive relief of specific performance would be no remedy at all. And in particular here, where the landlord has said, we'll never sign a cure agreement. What that means is that in order to get specific performance, you have to go and negotiate with HPD. You have to obtain new drawings and engineering and environmental studies and all of the tens of millions of dollars it would take to come up with a new cure agreement, present it to them, but the landlord said, I'm not going to sign it.
I thought you moved to compel them to sign it.
We moved them to compel them to sign an
Could you
agreement.
not have pursued that?
We did in
Oh,
2015.
no, could you not have continued to pursue that? Even in the face of their letter?
We were, in the face of their letter, that was an option that we had, but we also had the option to terminate.
I understand, but so that's an election you made.
Correct, and the lower court held
You
that we did not
probably-
have that election.
I'm
And
sorry,
so,
why did the lower court say you did not have that election?
because they held that it was a mere continuation of the behavior that had taken place in 2015, and it was new behavior, what the landlord had done on, quite obviously, the landlord went out to HPD.
Well, no, that's on the anticipatory breach, but I think you withdrew your claim for injunctive relief to compel them to sign, right?
That was already pending in 2015. And
Right.
so because what the landlord did in 2021 was fundamentally different. It said, we will never sign any cure agreement, and the
I'm sorry, so
cure,
what is it that stopped you from pursuing to conclusion your request for an affirmative injunction requiring them to sign the existing HPD agreement?
because prior to that point, the landlord had continuously taken the position that it would sign a cure agreement that did comply with the terms of the lease, that did contain, we had been litigating effectively
I understand
over
that.
whether what 15,000, approximately
You're not saying the
15,000 square feet
court
means.
had lacked the power to compel them to sign.
No, of course not. But let's take the counterfactual. Let's say that the trial court said, you know what, landlord is right. This is too many square feet and it doesn't comply with the terms of the lease. Go redesign a cure agreement. But in 2021, they've said, we're not
Just
going
means you might lose, but I mean, that's
no.
true of anyone.
But in 2021, in their June letter, they said,
We're
never-
I understand they said that. People say things in litigation all the time. That doesn't mean you can't go to a court and ask them to say they're wrong and we're right.
respectfully, I think we're very far afield of the 3211 scenario where this arose. All of these things are things that the landlord
I
can
think this relates
assert
to
at
we're
trial.
not far afield, I think. I think this relates to the question that Judge Rivera was asking you earlier about why you were saying that there's actually no relief available to you at all. And what I'm trying to probe at is whether there wasn't a form of full relief available to you in the form of specific forms that you affirmatively decided not to pursue.
The question is that if the right of termination arises, then it basically means that you're exercising that right without the possibility of a remedy. And that divests you of a remedy, of a common law remedy that appears nowhere in the contract. And so
Right. So what I understand you to be saying is, if I have the right to terminate an agreement or to compel specific performance, Because I don't want specific performance, I have no real remedy.
That's correct.
Okay? At least I understand where you are.
Okay.
Good afternoon. May it please the court. Jeffrey Turkel for the cross appellant. I'd like to reserve 3 minutes for rebuttal, please.
Yes.
I'd like to start with the sole remedy provision, 3309, which this court has repeatedly talked about. The Supreme Court and all 5 appellate division justices correctly found that 3309 applies to the particular breach alleged here with respect to the cure agreement. Where the courts went wrong was, and let me just say what that agreement said, 3309, it says, under this provision, whenever, very broad, a party unreasonably withholds consent or approval required under the lease, the other party waives to the fullest extent permitted by law any right to damages, and that such party's sole remedy for any wrongfully.
How do you respond to your adversary's argument, as I understand it, that the differences in the text of 1401 and 3309 mean that 1401 is not subject to 3309?
As this court knows from U.S. National Bank and Nomura and AmBank, it's kind of a cottage industry out there to try and evade sole remedy provisions when they rebound against you. 1401 speaks of in terms of cooperation. So what does cooperation mean under this lease? Well, we go to 3310, which is captioned cooperation. And 3310 says that both parties agree to cooperate with the other party in executing any and all documents necessary or appropriate under this lease where requested by other such party and otherwise give its approval to such documents as may be requested by the other party. So the concept of approval is part of the larger concept of cooperation. We get that from 1401, and then 1401 refers us to 3310.
But I think he's arguing, if I understand, that the language in 3309 is almost like a term of art, right? And that if the parties intended to have it applicable to 1401, then either in 1401 or perhaps in 3310, that those words would have been recited. And so I'm interested in your response to that.
Well, as I said, cooperation is a term that is used in 1401. Cooperation is defined in 3310 as encompassing approval. So I just don't think that it's that much. I mean, I think if you have to cooperate and execute, then you've previously already consented and approved. I think they're all melded within each other. The court has consistently talked about, well, why not go to Supreme Court and get the sole remedy that was given to you? And they did. And when they did, when they moved for injunctive relief 8 years ago, they sought an order directing the landlord to approve and execute the cure agreement, or in the alternative, to review and approve the cure agreement. So they are on record for at least 8 years in this case as saying that the gravamen of our complaint is you didn't approve the cure agreement that was put in front of you, and that puts us into 3309. Once we're in 3309, what do we have? We have a provision that gives them absolutely perfect relief. We don't want to sign, and if they're right that it was unreasonable, they go to court, and they did. They go to court, and they say, Your Honor, it's unreasonable, and then the court decides. In this particular case, the court said that there was a question of fact. If I were representing Authan, I'd be pursuing that injunctive remedy with everything that I had, because if it turned out that it was unreasonable, they'd have their cure agreement, and if it turns out that it was reasonable, the refusal to consent and approve, then they'd know they had to go back to the drawing board.
But, counsel, to get to your adversary's larger point in his argument, this is not just a refusal to cooperate. It's a statement that they're pointing to is a statement that this provision will never be realized because we will never sign that cure agreement, which they say elevates it to a much higher level, a repudiation of the entire contract. And what's most impactful to me in that argument is that this is getting decided at the pleading stage.
Understood, Your Honor.
What gives the courts below, the appellate division here, the right to do that sort of substantive analysis of what the meaning of the 2021 letter is in the context of a motion to dismiss?
There is federal authority, it's cited in our brief, for the proposition that a court can decide a matter of law where the alleged repudiation is in writing. So we have a written record. This is not he said, we have a written record of all the correspondence that went back and forth between HPD. I think what's more important is that when you look at well, let me make one other point. The question here is, was this a breach that falls in 3309? We say it is. If it is a breach that falls in 3309, then 3309 applies and the sole remedy provision applies. It doesn't matter whether the breach is material, non-material, total, partial, or anticipatory. A breach is a breach. Now, an anticipatory breach would give them the right of election, but that's not really involved in this case. So a breach is a breach, whether we call it anticipatory or not. The last thing that I want to say is that—
Well, can we send it back for them to pursue their specific performance remedy?
their specific performance remedy is moot. They moved. They vacated. That's it. It's over. It would just be an advisory opinion.
You mean they vacated the premises?
They vacated the premises. They can't be put back in. They're gone. When courts talk about anticipatory repudiation, they talk about an unequivocal and final refusal to perform. 3309 does not give the landlord that ability to refuse to perform. As Judge Wilson repeatedly said, go to court, use your sole remedy, get your injunction, and if they direct the landlord to sign, then you've got everything that you wanted. You've got—
So is your position there can be no repudiation as a matter of law for that reason?
Yes. Yes. I think when an anticipatory repudiation is in essence—
Seems like a big carve-out of what we think of viable repudiation claims. That would mean that anytime someone says, I refuse to do X despite my promise in a contract, that there's no repudiation because the other party can go to court and compel you to do it?
Well, it's not that the other party can go to court and compel you. It's that this contract had a specific sole remedy provision that said that is your remedy.
You're not, are you disputing that if they had, let's suppose they could prove that you repudiated the contract, right? Let's suppose they could, let's take that for granted. Let's say you did repudiate it, right? Would that give them the right to walk away from the contract?
No.
Oh, it wouldn't?
No,
in your
because
view?
their sole remedy— again, it doesn't matter whether it's an anticipatory breach, material breach, partial breach. Their sole remedy, they gave away what they're seeking.
What if they don't want a remedy? That is, to put it differently, let's say that they decide enough time has passed and this is, you guys are just horrible people to deal with and they just don't want to go forward, and they just drop their lawsuit. Can you sue them for not going forward?
It didn't happen, and I don't know
And
if
ask
we—
for specific performance? Because you can't ask for damages under your theory.
No, I think we would have let them go. That's—
Well, so what, I'm not really asking what you would have done, but what you could have done. I mean, it would seem to me that if somebody repudiates a contract, that gives them the right to walk away from it, if the other party the right to walk away from it.
I would disagree. I would say that if you have a sole remedy provision that says you have to get injunctive relief, the fact that a breach is anticipatory rather than material or partial or whatever doesn't take 3309 out of the contract. They waived their right to seek contract damages, which is what they're doing here, which is what they're before
You're
the
saying
court
they
here.
also waived, I think, you're saying they also waived the right to effectively repudiate. So I guess it would be helpful, what's the best case support for that proposition? I take it what you're saying is that where you have a provision like 3309, you essentially can't repudiate because your sole remedy is to go to court under a provision like 3309 and seek specific performance. So if you're suggesting repudiation is contoured in that way, or there's a bite out of it that way, what's the best support for that?
I think the best support is Nomura, U.S. Bank, and AMBAC. Those were sole remedy provisions, and in each of those cases, the plaintiff thought of some very clever and inventive way as to why that sole remedy provision, to which they agreed, should not apply.
If I recall, not specifically, and I might be remembering those cases wrong, but not specifically with respect to whether repudiation was available in the face of a provision like 3309.
Well,
Is that
Your Honor,
right?
in Noble Lowndes, that was a repudiation case, and the court enforced the limitation of remedies provision.
Okay,
It
so
was
if I-
against consequential damages.
If I'm understanding you, your view, based on your responses, both Chief Judge and Judge Halligan, is that they could have sought, and they did, injunctive relief, but then they walked away from that, and then they walked away from the agreement. They picked up and left the premises. And so at that point, they don't get to say, we've suffered financial damages as a result of your anticipatory breach, and we're going to pursue that in court. You're saying they don't get to do that because all they could do is request that we comply with the agreement as written, which is we had to sign off documents, not withhold our cooperation, approve, et cetera, and so forth. But if they walk away, regardless of whether or not they're seeking damages against you, monetary damages, you could have chosen not to pursue an action against them. As you said before, we would have let them go.
We would always have that remedy. That's correct, Your Honor.
So just to kind of clarify what you see as the actions before you.
I mean, I think what we have to look at is what was the intent of the parties at the time that this lease was signed, okay? The idea was that if there was a dispute as to consent and approval, and let's face it, even though the clause is mutual, it's obviously weighing more heavily on the landlord because the landlord is going to be asked to consent and to approve for various documents. The landlord did not want a case where there was a question about whether a refusal to give consent was unreasonable enough. Because if you could get money damages for that in a development deal that's almost 100 years old, the damages could be absolutely astronomical. The landlord did not want to get involved in that. So there's a provision in there, and they said that we waive damages, we waive money damages to the fullest extent allowed by law. And you don't get to evade that by saying, well, it's an anticipatory breach instead of a material breach, instead of a partial breach. 3309 means what it says. This is freedom to contract. 3311
Bad
specific.
faith,
I'm sorry.
if there is allegations of bad faith, does that come into play or impacted in
No,
any way?
it doesn't, Your Honor. That's where 60 putback litigation comes in. In Kalish-Jarko, the court said, we're not going to enforce exculpatory clauses that purport to insulate a party for their bad acts or gross negligence. And in 60 putback, the court said, well, let's take a look at that. And its analysis was, the first thing we have to do before going into the issue of gross negligence or bad acts is determine whether we really have an exculpatory clause, because the public policy relates to exculpatory
That's
clauses.
your argument here, counsel. Was that your argument below?
Well, we've always argued that 3309 applies and limits
No,
the
this
remedy.
bad faith argument. Did you make
Well,
that
we-
argument below, that this just doesn't apply here?
Yes, under Noble Lowndes, we certainly did, because Noble Lowndes says,
I thought your argument was you didn't engage in bad faith below.
no, we certainly argued Noble Lowndes, and we said that under Noble Lowndes, if there's an element of economic self-interest to the conduct that is alleged to be bad faith, then that doesn't constitute the kind of bad faith or willful act that would cause a court not to enforce a provision between two sophisticated parties that's unambiguous. So that was definitely argued below.
That part of your argument was.
Yes, that is there below. I see my time is up.
You have your rebuttal.
Thank you.
Counsel, could you start on this preservation issue? Was that an accurate recounting of, in your view, of what the arguments were below?
No, I don't believe it was. The economic self-interest argument goes to the Kalish-Jarko framework of whether there are allegations that a counterparty engaged in conduct that would vitiate an exculpatory clause. And then the issue of 60 putback, which was not raised in the appellate division and was not raised until the briefing before this court, is whether that framework applies in the context of an exclusive remedy provision. And so that was not raised or briefed below.
In fact, it was almost conceded, I think, that it did.
The framework under which the parties argued was under the Kalish-Jarko and which the courts below rendered their decisions was there, and so that they didn't raise the argument. They raised it here for the first time, and it's a substantively different argument to say I had a financial, economic self-interest, and this is a sole remedy clause, not an exculpatory clause.
And so where in the record do we see that? Are you saying that this was just generally the way it was teed up, or is there a specific concession somewhere in the record to that effect?
We cited to the parties' briefs below in our brief here, in our reply brief, so the court can look at those briefs and see that it wasn't in fact argued in that way. And of course, the way the courts below decided the question was without reference to 60 putback and this
But it sounds like it's implicit, if I'm understanding you and my reading of the briefs, was that it's implicit in the way the issue was argued as opposed to an affirmative statement along the lines of what you're identifying. Is that fair or no?
I'm not sure I follow you, to be honest. I think that the 60 putback argument, let's call it, is an argument that this is a sole remedy provision, and therefore the analysis under Kalish-Jarko does not apply. That was not an argument that they made below. The argument that they made below was you haven't alleged sufficient
Right.
bad faith
But my
conduct.
question was, the inverse was not stated. Is that right, that 60 putback does not apply? In other words, that as a doctrinal matter, that it's irrelevant?
No, they made their motion to dismiss, and we responded to it.
Okay, thank you.
I want to get back to something my friend on the other side said, which is that, which was sort of taken as a given that Section 3309 applies, and that therefore the intent of the parties was a waiver of the right to seek damages. Now, of course, it's black letter law that the intent of the parties is best defined by the language that they used. And in order to get to where the other side is going here, that Section 33.09 applies to Section 14.01, you have to move around a whole bunch to different places in the agreement. You don't have to do that with respect to the 22 separate places in which the specific language, the term of art, as Judge Halligan mentioned it, applies. It would have been very easy to do that in Section 14.01, and the parties did not do that. And they didn't do that because the contours of and the need for, first, the Section 14.01 begins with the parties acknowledge that a harassment finding has been made, that a cure agreement is needed, that no development can happen without such an agreement. It was by signing the lease, the landlord consented and approved of a cure agreement. And what it did in 2021 was said, that obligation doesn't apply to me anymore. And in their brief, they come out and say, what we were trying to do was to obviate our contractual obligation.
Counsel, what are we to make of the fact that prior to 2021, with respect to the obligations that are incurred under 1401, you were seeking injunctive relief, the very remedy that is referenced in 3309?
We were seeking injunctive relief because what landlord had done, it didn't say we will never sign a cure agreement. It didn't say no cure is warranted. No cure is warranted is a rejection of the fundamental purpose of the lease, which is that you have to get a cure to develop this agreement and to make a declaration of condo. What we thought we were litigating about was, does the cure agreement that we tendered have the appropriate amount of square footage? After which the landlord said, you know, if a redesigned cure agreement, we'll sign it. One that doesn't take away the couple hundred square feet that maybe you've gone over here, we'll sign that agreement. And what they did in 2021 was say, no, the cure isn't warranted anymore because of these accusations that I'm now making against my client and its principals. And that's a fundamentally different thing. That went to the core purpose of the lease. What the landlord did in 2015 was say, you know what, I think this agreement may be giving away too much. And we were litigating about what approximately 15,000 square feet means. And that's a very different thing than the landlord coming back and saying, we'll never do this.
So are you saying that up until that point you were in 3309 prior to the 2021 letter, but the 2021 letter so fundamentally changes the nature of the breach that you're released from your obligations under 3309?
No, I'm not saying that at all. 3309 simply doesn't apply. In 2000, we have a common law right to seek
So you just elected a
We,
remedy?
no, we elected to seek specific performance and an injunction compelling them to sign, and money damages for the delay occasioned by the refusal to sign that agreement. Because the refusal to sign that agreement meant that we were carrying the costs of this building, paying rent, doing all sorts of things, keeping employees on staff, and lo and behold, that actually amounted to a great deal of money because the landlord kept attempting to terminate the lease and to prolong the litigation over 6 years.
So is that?
So there were substantial money damages.
Is that a refusal to cooperate, consent, or approve, or all of the above?
It was a refusal to cooperate in executing an agreement, we said. We said that the refusal to sign was pretextual and wrong and wrongful, and there was an issue of fact as to whether that was the case. But
Just to be clear, are you also saying that, let me put it this way, under your view of the case, who had to approve that HPD cure? HPD, the parties, who had to approve? Since you're saying all they had to do is cooperate, so who had to approve?
by signing the agreement, they approved of a cure that provided for the development of a 58,000 square foot building and a permanent creation of 15,000 square feet. Once those two conditions are satisfied, then we comply with the terms of the lease, and the landlord has to sign it. The landlord doesn't get to look, to page through it and say, you know, I have a problem with a provision. The only thing, the only reason that they could refuse to sign was it didn't do what the lease said it had to do in Section 14.
I think I now fully appreciate your argument. You're saying they've already approved the cure and most of the terms of that cure, so they could never not approve because they've already approved.
That's correct.
And that's why it doesn't fit under this provision.
It is the central purpose of the lease, both as acknowledged in Section 14 of the lease and as alleged in the complaint. Whereas in the consent and approval land, getting a sublessor is not the most important thing that my client is going to do.
So, I'm sorry, so since they've already approved, however, when they commit the alleged first brief, they're simply not cooperating? That's what you call that?
They're not cooperating in executing the agreement in the rubric of the lease, in the black letter.
Even though cooperation refers to documents, not the agreement?
They're supposed to cooperate in executing documents that comply with the terms of the lease. And so the only grounds under which they could refuse to sign an agreement, was if it did not comply with the terms of the lease. And here, with respect to a cure agreement, the reasons to comply with the lease had to provide for a condominium of a certain number of square feet and square footage of affordable housing that was approximately 15,000. And landlord, unlike the places where their consent or approval could not be unreasonably withheld, didn't have any discretion there because, as you say, Judge Rivera, their approval and consent was baked in when they signed the lease. This was pre-negotiated, unlike the other things.
I'll be extremely brief, Your Honor. There's no concept of pre-approval in this lease. Anytime a cure agreement was submitted...
What did you agree to?
I'm sorry?
What did you agree to?
We agreed to sign, or we agreed to not unreasonably withhold consent or approval to any document, but we had the right to refuse to do so if we believed that it was inconsistent with the lease, and that's the position that we took since 2016. They went to court. They said it's within the lease. We said it's contrary to the lease. I wish we would have gone to court. I wish they would have pursued it. I wish we would have found out 8 years ago, but unfortunately we didn't. Counsel says in his brief, and he just said, that if you look at the record, we always said, well, if they give us a good one, we'll sign it, we'll sign it, we'll sign it. There's nothing in the record that says that. Absolutely nothing. Check the record sites.
What were you communicating to them the first time?
We were saying we're not signing this because you're asking for more square footage for low...
Affordable housing.
Affordable, thank you, affordable than that's permitted. We were absolutely willing to litigate that, and they never pursued it. And if they had pursued it, we would be in a totally different posture here.
And the flip side of that isn't, and if you took care of that we have no other problem with this document? If that's the only problem you identified, and they went about the business of resolving that, would you have to sign?
If the court ruled that it wasn't contrary at that point, we would have had to sign. That's correct. We didn't know about the serial harassment at that time in 2016.
No, I understand you think you've got a different basis for what they claim is the second alleged breach, anticipatory breach, however you want to call it. You said any breach is a breach, so I'll go with that for the moment. But then once you make a different statement, aren't they then able to read that statement for purposes of the motion to dismiss in their complaint as now it is not a question of whether or not we can resolve the dispute, but this is completely off the table, which is contrary to the arrangement we entered into, which is that they would cooperate with the documents as long as it fit whatever categories you all agreed to, right?
Right.
Is that not an inference that can be made? It's a motion to dismiss.
Not if we give 3309 its due and its effect. A breach is a breach is a breach. They're saying we're refusing to consent and approve, whether it's this one or forever and ever. That is where this falls, and their sole remedy.
But would you not agree that there are, yes, a breach may be a breach, but the substance of the breach is what you're debating, right?
Your Honor,
So the first breach is you're not agreeing to this, or you're not cooperating, but they're arguing it satisfies all the requirements. You have no basis not to cooperate. The second one is you've absolutely taken cooperation off the table. You will never sign off on this. There's nothing we can do to get you there.
I think the
It
statement
does seem substantively different, no?
I think that if one ignores the fact that statement that we will never sign it is absurd in view of 3309, which gives them the right to go to court and get us to sign. And even if we refuse to sign at that point, the court would have deemed it signed. They had a perfect remedy under a clause that gave them perfect relief. They decided not to exercise it, and they decided to seek damages that they waived to the fullest extent of the law. Thank you.
Thank you. Next matter on the calendar is matter of Aaron Manor Rehabilitation versus Zucker.
Good afternoon, Your Honors. Kate Nevue for defendants. I'd like to reserve 5 minutes for rebuttal, please.
Yes.
Your Honors, the legislature mandated removal of this payment factor as of April 1st, 2020, in an act that it didn't even vote on until April 2nd of 2020, and with the full knowledge that it takes time for reimbursement rates to be recalculated. It therefore must have intended that the removal of this payment rate be retroactive. There are 3 provisions of the Act that demonstrate the legislature's intent here. First, it used a notwithstanding clause, which is a commonly used and well-understood provision that says that something supersedes any inconsistent
But
provision.
we've said that's not enough in the retroactivity context, right?
Well, we're not asking you to find that that alone is sufficient. There are 2 other aspects of the Act. The second is that the removal was mandated for rate periods on and after April 1st of 2020. The only way to give meaning to the on and after part of that provision is to interpret it as authorizing the department to reach back to April 1st in order when it removes the payment factor.
Why aren't they right, though, that given the way rates are actually determined, that could only mean rates at that future calendar date, the next calendar year?
Rate periods are not necessarily calendar years, Your Honor. If you look at throughout Public Health Law 2808, there are multiple rate periods defined in the statute. Not all of them are calendar years, not even all of them are even fiscal years. Some of them are a single month. Some of them are a span of months. If that's not sufficient as to what a rate period is, even plaintiffs agree that it's a term of art, which means that the department's definition of a term of art is entitled to deference, and the department defines it as a period for which a rate applies.
Is this really a question of statutory retroactivity? I mean, I understand that the letter is in August, and it apparently has effect reaching back, as I think you just said. But why is the question whether that is retroactive as opposed to whether the statute has retroactive application, and perhaps it doesn't because it's effective as of a date specified in the statute itself?
Well, the statutory retroactivity is because it was passed on April 3rd.
Yes.
And it says, you know, that both the rate, that the removal.
For that day or two?
Right, yes.
Right. But if we
For-
set that aside,
Yes.
well, let me ask you first, if given that day or two, would that be enough to mean that the statute lacked valid application from April 3rd, the day of enactment, going forward? Or is it simply a question, if we're going to look at the retroactivity, qual retroactivity, of what happens with the first and the second, which I think are the day or two between the date specified in the statute and the date in which it's enacted, if that makes sense?
Yes, it's kind of the same analysis, Your Honor, because the legislative intent is clear on both grounds. First, that the statute enacted on April 3rd takes effect, shall be deemed, in fact, to have been in full force and effect on and after April 1st, which the effective date language, the third part of the Act's provision says, and also that the intent is clear that the legislature's waiving the 60-day advance notice requirement, which it created, and which it creates exceptions to all the time. It's important to realize here that the legislature knows how Medicaid works. The legislature created the advance notice requirement, and then it created a bunch of exceptions.
Counsel,
Yes,
I
Your
don't
Honor.
find the statutory language so crystal clear as you do, and let me explain to you why, and you can tell me where I go wrong. You know, presumably the legislature knew when it enacted this statute that there had been a determination, you know, these things are set up annually to run from a period, I think, that begins April 1st and goes through for a year following that. Is that right?
The rates here, they're usually done on a calendar year.
Yeah.
In this case, the legislature directed that they be changed to run with the fiscal year.
Right.
Yes, Tom, go
So
ahead.
previously, it had been set up at the beginning of the calendar year, and they were aware that reimbursements were being made under that regime. And they enact a statute that says that there shall no longer be a payment factor for residual equity reimbursements, meaning, you know, we're not going to do that going forward. But they don't specifically mention a stop to reimbursements that had been set up under the previous implementation of the Act. So my feeling is the legislative language could have been clearer as to retroactive intent if the legislature said, stop reimbursing now.
Well, Your Honor, the legislature said for rate periods on and after April 1st, there shall be no payment factor. So that indicates that as of April 1st, you have to take the payment factor out of their rates. And that makes sense with what was going on in the world at the time. As the court may remember, in April 2020, the state was facing an enormous fiscal crisis. Even before COVID hit, the state budget needed to close a $3 billion gap. So there's no way that the legislature could have intended to wait on these savings until the next year.
Does the record tell us why there's there's a gap of about 4 months between the statute being enacted and the Dear Administrator letter?
Yes, the state had to recalculate the rates. It has to send them to the director of the budget to be approved.
just normal course of
Yes,
business,
just the
not
normal
anything
course of events.
So I'm not sure why this is being described, other than the 2 days, which we could set aside for the moment, as applying our retroactivity analysis to it at all. It seems to me that what I'm hearing is it's a question of when the legislature enacted the statute, did it intend for there to be a period to allow the regulators to set new rates, or did it intend to disable the regulators at that moment? But that doesn't seem to be a question of retroactivity at all. That's just a pure question of legislative intent.
Yeah, and the legislative intent here is itself clear, that under the circumstances, this removal of the payment factor was a recommendation of the Medicaid redesign team, which had been constituted that year, or reconstituted rather, in order to find $2.5 billion in savings because of the budget gap that the state had already been facing. It had recommended both the removal of this and the 5% cut across the board to capital rates.
Let me,
Yes.
if I'm understanding the Chief Judge's question to you, I'm not sure you're directly responding to it. I thought the question is, why is it about retroactivity moving forward? Because I thought, why is it about retroactivity? And is it because rates had already been set, and as you were responding to Judge Halligan, those had to be recalculated?
Yes.
Otherwise, you were bound to those rates?
Yes, they had to be recalculated, and ordinarily, the legislature has required a 60-day advance notice for that. But this was passed notwithstanding any contrary provision of law, as, on and after April 1st, which means that the 60-day notice requirement didn't apply, and the legislature was directing the department, when you recalculate these rates, recalculate them back to April 1st.
Were the new rates ever put into effect?
No, because of a preliminary injunction, and then.
And that's still in effect?
That's still in effect, Your Honor, which is why approximately $374 million has been paid to plaintiffs through the end of this calendar year under that injunction. As I just want to emphasize that given the fiscal crisis at the time, given the three aspects of the statutory language, it's clear that the legislature intended that these rate changes be made effective as of April 1st. The appellate division erred when it said it couldn't find any clear expression of that legislative intent here. And that change is not meant, as plaintiffs suggest, it's to crash the nursing home industry. Nobody wants the nursing home industry to fail. I see that my time's
The
up.
red light is on. Can I just ask
Yes.
you, if the Chief Judge allows, just take perhaps a very brief opportunity to address the 7807 argument? The 2807 argument, excuse me.
Yes.
I inverted the numbers, sorry.
No, that's fine. Your Honor, the department was not required to recalculate plaintiffs' rates to see if they met the statutory standard in 28073 before they removed the payment factor from their rates. That's because the legislature said you must remove this payment factor notwithstanding any contrary provision of law. And so that forecloses plaintiffs from saying, just because you took away this payment factor, my rates don't meet the standard. Certainly, plaintiffs can challenge their rates overall on other grounds, but they would have had to do so by showing their individual costs and how the new rates didn't meet those individual costs. And that would be particularly important here because
If I'm understanding you, the flaw from your perspective in their challenge is that they're challenging the rates writ large, although they always retain, I hear you saying, and I thought that's how I read the briefing, the opportunity to challenge the reimbursement to an individual facility.
absolutely,
To say it's not reasonable in light of our costs and our expenditures.
that's exactly correct, Your Honor, yes. I see that my light is on, and I will reserve my time for rebuttal. Thank you, Your Honors.
Thank you.
Good afternoon, F. Paul Green on behalf of Cross Appellants. May it please the court, I'd like to reserve 3 minutes for rebuttal, if I may.
Yes.
I wanted to address this issue of statutory retroactivity in the first instance. There was statutory retroactivity here because we need to understand how capital works. And capital is set on an annual basis, and that's very important, because capital is one of the 4 necessary components of the rate. It is perhaps one of the most important components of the rate, paying for the home in which these residents reside. And think about it. You need to know, at least, running any business, you need to know for a certain amount of time how much money you're going to have to pay for that facility. Imagine going to a mortgage lender and saying, my income for this mortgage may change on a daily basis. And we have 2 protections in that regard. The department has built this yearly structure. It's their own structure. Their own documents prove this structure. This is record at 352. That's one of their documents, I believe. It's actually the rate sheet.
But are you saying that the legislature is disabled from removing that structure?
No, not at all. But it certainly, as
Well, and if it removed it, it might disrupt everything in the way you were just alluding to.
exactly. What I'm getting at here and discussing are the rights involved. And those rights were set as of November 1, 2019, for all of calendar year.
Yeah, but the legislature's not, I think you just told me, disabled from changing that like this.
Correct. And
Is
what
your
the
point
legislature...
that it would be a retroactive application? By changing it in April, you have a retroactive effect on the rates that have already been set.
On the rate period, exactly.
What does that mean on the rate period?
So that was a specific term that the legislature chose, a specific term of art, and that in relation to
The
capital.
rate period?
Rate period. It's
Oh,
in
the
statute.
rate period. I thought you meant rate, comma, period. I understand. Thank you.
Pardon me.
So you had a one, from November 1st of the previous year, you had a 1-year expectation that your rates were
They were set.
Not just an expectation, it's a certification by the
But I
Department of
thought,
Health.
do you disagree with your adversary's comment that that is something that can be changed if that's something that the administrator wants to do? Or is it your position that the administrator is statutorily disabled from changing it?
I thought the question was going to be, can the legislature change it?
No.
I think you answered that, the legislature can change it.
Yes.
And here they chose not to. They used the term rate period. They said, with the next rate period, remove
But
residual equity.
Is it your view that the administrator lacks statutory authority to vary the rate period? And if so, where do we look for that?
No, I don't think that the commissioner lacks statutory authority, but that brings us to 28077, the 60-day notice provision.
But that's something that, I take it, given your answer to the chief judge, you would say the legislature can change or no?
Certainly, they can create an exception to 28077, and the statement from my adversary was, the legislature does this all the time. Not true. They did it once. That was in 280811. It was a number of years ago. And this court found in Jewish Home that that was an exclusive list of the exceptions to 28077.
So your position is that the legislature could not or did not? I'm not sure which
Did not.
one.
Absolutely did
Did
not.
not,
They could have, but they didn't.
Correct.
didn't waive the 60-day period.
So if we disagree with you on both those points, do you lose, do they win?
If the 2 points being that they,
You've just said the legislature could have done these things.
Correct.
But your argument is that's not what they did.
They did not.
Her argument, of course, is that is what they did. So if we agree with her, is that part of the case done?
certainly if you find that the legislature expressly said, this shall be a new exception to 28077, then we lose. But the legislature did not do that, and that's clear in a number of
But
places.
that really has nothing to do with retroactivity, no? That's just pure statute. What did the legislature intend?
This gets back to my first point. There's statutory retroactivity, and I believe there is statutory retroactivity in the fact that they are changing rights that accrued as of January 1. That rate period is 1 year. They knew that, and according to the reading of respondents, not according to the clear text of the statute, but according to the reading of appellants, pardon me.
Then what does the April 1 do in the statute? Why is it there?
The April 1 is there to give the Department of Health enough time to do all of those things to get this change in the books. The appellants admit that they needed to change the regulations. The regulation for residual reimbursement is still on the books, 86.2.21. That takes time. Under SAPA, State Administrative Procedure Act, takes at least 60 days of notice. They needed to recalculate the rates. They needed to do all of those things, submit a state plan amendment. What the legislature was telling the commissioner at the time was, get a move on,
So the
remove this
legislature was
factor.
telling them they have 7 months
Yes.
to change the reimbursement scheme for November 1st of the coming year,
For the next applicable rate period, correct?
whenever the next rate period calculation takes place.
Correct.
But it seems the legislature would have said, effective the next rate period.
They did, for rate periods on and after. And
but they
and the
said
on and
didn't-
after, if I'm, oh,
ahead.
go ahead. Oh, the on and after is there for once.
It's very nice rhetoric, but it's not helping me. Okay. On or after means moving forward, but if they really meant, not as of today, or whatever day they chose, but rather at the next cycle, would they not have said that very clearly?
I think they did.
Especially since, well, I know you think they did, but I'm asking you, if I disagreed with you, how would you persuade me of that? That's my point.
There are
What's the
two
analysis
phrases.
behind that? Because remember, she's also arguing that the state is in a major fiscal crisis. If you take that in context, in addition to the plain language, take that in context, there's only one reading of that language.
There is only one reading of that language, and it's according to its plain terms. The legislature uses two phrases when it talks about commencement date in Public Health Law 2808. It either says commencing on, or it says rate periods on and after. Those are the two choices. Commencing on means commencing on, and that is shown by this very bill. Appellants reference this change. They say changes to the rate happen all the time. In this same bill, there was a 5% reduction to capital overall to address the potential.
So where in the statute do we know that rate periods on and after April 1st, 2020 does not give any room or does not in fact instruct that the rate period without this reimbursement will commence on that date and run forward?
It is not a defined term in the statute, and so it is a factual issue as to what that means. In practice, it is a rate year, and they've
I don't
admitted
know
that
what
it's
it
a rate
means
year.
for a question of statutory interpretation to be a factual issue. Generally, I think we look to understand the legislature's intent when we're reading a statute. So what are the interpretive guideposts that you would point us to read it in the way that you're proposing as opposed to the way your adversary proposes?
As appellants state, we need to expect that the legislature knows how the system works, and we need to assume that the legislature knows that a rate period for capital is 1 year, 1 calendar year, and 1 calendar year only.
And is there anything in the legislative history which confirms that?
There is no legislative history one way or
Right.
the other.
Yeah.
But if it also knows, as she has argued, that there are these other provisions that do allow for rate changes during other times of the calendar year, why wouldn't the legislature think, I can change it from now forward?
They use different language, and that was in this budget bill that I was addressing. The 5% reduction.
The one you're not challenging.
Pardon?
The one you're not challenging.
Correct. We're not challenging that, and that began commencing April 1. Same bill, two different phrases. Commencing as opposed to for rate periods on and after. If they meant commencing for capital, they would have said commencing, period.
So if they had simply replaced commencing, on or after, with commencing, that would have signaled an unambiguous intent to stop the reimbursements effective April 1st.
The clear expression. If I may.
Isn't that the requirement? I mean, it's a retroactivity analysis, so the presumption is it's not. So it seems to me you don't have to prove that they intended it to be prospective only. You just have to show they didn't clearly indicate it was retroactive.
That's exactly it. The presumption that they could change those rights midstream is that they could not do that retroactively, and they need to show the clear expression.
But doesn't that, let's set to the side, if we can, the question of April 1st and 2nd, okay? Other than that, doesn't the question of whether it's retroactive, as I think the Chief Judge's question previously indicated, turn on whether or not there is no authority to vary a rate period? I mean, otherwise, how is it retroactive in any sense?
That's 28077, and that's kind of the lowercase retroactivity here. That's the administrative action, the as-applied action that ended up being retroactive.
You mean the letter on the 4th?
Correct.
But the letter on the 4th,
The letter in August.
sorry, in August, yes. The letter in August, I mean, your argument is that that has impermissible retroactive activity separate and apart from whatever the legislature set forth in the statute?
This court is bound to read those two statutes together, 280820D.
The Dear Administrator letter is not a statute. That's what I'm referring to.
I'm referring to the intent of the legislature as expressed in 2808-20D, and we need to read 20D together with 28077. 20D says take the factor away with the next rate period. 28077 says give 60 days notice. Those are entirely congruent, telling the commissioner, go give notice, do all of that work, give your notice, and then start it with the next rate period. We believe the letter was improper because it did not give that notice under 28077 period.
So, but you would agree, would you not, that if the legislature had intended to change the rates effective April 1st of that year, 2807 wouldn't have been an impediment to the legislature doing
Correct.
that?
It would have had to create an exception. It would have had to say that 2807 does not apply, 2807
And the
does not apply.
notwithstanding language of the enactment doesn't take care of that
It
problem?
does not.
for
It
the
says
legislature?
notwithstanding any contrary provision of law, and it was adopted in 2011. I question whether, as a matter of English grammar, the notwithstanding applies to the subordinate clause that's about 35 words away. But in 2001, they adopted that notwithstanding clause, and the laws in 2001 said, this act shall not be construed to alter, change, affect, impair, or defeat any rights, obligations, duties, or interests accrued, incurred, or conferred prior to the effective date of the statute. So by definition, that notwithstanding clause is not retroactive. If I may briefly, on my cross appeal on the two extra.
Before you go to that, I'm sorry, I'm going to have you step back, because I'm having difficulty understanding your argument about the use of the word commencing. If we swap on or after for commencing, why do you have a date? And why wouldn't the date be what you say is the understood commencement date of rate periods historically?
I think you need a date in both situations. You do commencing
No,
April
but why
1.
is the date April then? Why isn't it the date that you say everyone understands that's when the rate period commences?
As we showed you for the on and after language,
Yes.
as we
I
showed,
thought that's what you said.
as we showed in our papers.
That's the difference. One section had the 5%.
Correct.
Had commencing, and this has something else. So they must have meant something else here.
Yes.
Yes.
As we showed in our papers in relation to the capital rate, sometimes, very rarely, sometimes a capital rate can begin mid-year. If you go out and get a new mortgage, you have a capital rate beginning with that mortgage. So the legislature, we need to assume they knew that this was part of the program, part of the plan. They said, okay, well, if you have any new rate periods starting after April 1, that's where you start, any new rate periods.
But I'm
That's
saying,
why-
why would you pick, my point is, why are you picking, for this provision we're talking about, the one you are challenging, why would you pick April if you know that it's, the rate period itself
They were
is
trying to-
months away?
They were trying to capture every single rate period in between. There are rate periods with nursing homes in 2020, between April and January the next year, just not for any of the plaintiffs, period. And so the legislature was clearly saying, if there's a new rate
Why are
period.
they not for the plaintiffs? I'm sorry, that I did not understand.
Oh, it's only when you go out and get new financing or build
Oh,
a
I
new
see.
building, for example.
I see.
Very rare circumstances. With 600 nursing homes, there's always a rate period that falls mid-year. The next year, by the way, it goes back on an annual basis. So it's not true that the rate year has been changed to a fiscal year.
I understand that.
Yeah. But they said on and after April 1 to capture any new rate period after that date.
They didn't say any new rate periods. They said any period. They didn't
But I
say
think
any
that's the only
new.
way one could, pardon me. That's the only way one can read for rate periods on and after, because rate periods always begin anew. It's a rate period set for a year, and the next rate period is a new rate period. I see my time is up.
Thank you.
Okay, just to finish this off, what's your response to this argument about the use of the word commencement or commencing in a different provision, and how it perhaps suggests what the legislature intended with this provision?
Your Honor, the legislature uses 5 different ways in 2808 to say that a rate change is going to start on a particular date and go forward after that. So there's no code, there's no significance. It's just different ways of getting across the same concept. I'm happy to list those if the court would like, but they all mean the same thing. And you can't make any meaning out of on April 1st if it doesn't, the removal doesn't happen as of April 1st when it's eventually calculated.
Well, I guess the question is, why add the word rate period there?
Again, a rate period is simply, it's the period for which a particular rate is paid. The
Yeah, but you're giving
legislature.
those words no meaning, I guess. If you just struck them, would mean the same thing.
I mean, it's the same way as saying commencing on date for rates of payment. It's the same as saying effective date and thereafter. They're just different ways of referring, a different drafting approach to referring to the same period. And it can't be that a rate period on April 1st means that it really somehow only applies to January of 2021, especially under the circumstances.
But what it could mean is that the rate period that had been established on November 1st, 2019 is in place, and now April 1st is certainly after that.
On April 1st, you're within a previously existing rate period, but you're still in a rate period. And in order to give effect to the removal that there shall be no payment factor on April 1st, then the legislature's created a new rate period,
So let me
which the
ask you this.
legislature does.
If on May 1st, a nursing home goes out and does the sort of thing that council described, that is, gets large new refinancing for its home, when would that new rate period start?
If it starts after April 1st, it's still on and after, so the removal would still apply there. I don't,
No,
I'm sorry, I don't think I understood your question
Yeah, sure.
properly.
If
Your
I
Honor.
understood counsel correctly, he said that although rate periods are annual, and they sort of are for everybody, there are certain events that can happen in the middle of a year that cause that particular nursing home to have a new rate period for the stub end of the year. Is that comport with your understanding?
Yes, Your Honor.
Okay. And one of those things, just as an example, might be you went out and got a complete new refinancing. And so then my question is, suppose that happened May 1st. Would that new period start May 1st, or would it start 60 days after May? When would that start?
It's my understanding that it would, and I'm happy to check on this, Your Honor, but suppose it starts May 1st, even if the,
Well, I don't want to suppose. I'm looking for a factual answer. If you don't know, it's okay.
yeah, I'm not sure.
Okay.
But if it starts May 1st, even if the department has to calculate it later, doesn't calculate it until June or whatever, it's still effective as of May 1st. And that is a change that's reaching
So that the
back.
nursing home would get the benefit of that, presumably, if that refinancing caused them to get a greater reimbursement.
Yes.
And is
And
that,
it's the same, yes, Your Honor.
is that retroactive, or is that something that is in effect but not yet implemented?
It's,
In other words,
yes, I understand what you're asking, Your Honor. They tend to use it the terms interchangeably, which I
the they
understand.
being-
The department.
Uh-huh.
Which I understand is confusing when we're talking about statutory retroactivity as well. But this idea of non-statutory retroactivity is basically without the prospective notice in 28077, which, as the court has mentioned, this change was made notwithstanding any contrary provision of law, and that includes the 60-day advance notice.
Counsel, we've said repeatedly that the best way to do this is to really make your intention clear. This was a change that affected a rate that had been set for all of 2020, and it had pretty big financial impact. There's agreement, it seems, that the state could do this, the legislature could do this. Why not make it clear? Why are we here debating on whether the notwithstanding clause with an April 1st date, with a time period that could run the full year or not run the full year? Wouldn't it be easier, and wouldn't it be a better message to say, if you want to do that, do it, but do it in a way so we don't have to do this again?
Well, I certainly would hope that, the legislature is taking note of this, but as it is.
And the other cases that we've had, some fairly recently, where we've made this same point.
But as it is, there's nothing, the legislature directed, as it does often in the budget, that this change shall be deemed to have been in full force and effect on and after April 1st. What could possibly that provision mean if not?
What if it means a partial new payment that we've been talking about, a reset on a reset that starts a new rate period running on May 1st? It could mean that.
What plaintiffs are principally arguing is, it means that they need to start working on the rates. It's not as though the department's going to time travel back to April 1st and start working on the rates before the act is even passed. There shall be no payment factor on and after April 1st. That shall be deemed to have been in effect. Those are pretty clear, and that's more than sufficiently clear. The appellate division erred in finding that it wasn't clear enough for these purposes, particularly when, as stated here, it's fully within the power
The
of the
Supreme
legislature.
Court also, what did the Supreme Court rule here? I'm sorry, I really can't remember for the moment. Did they rule it was retroactive or not effect? Did they agree with the appellate division? Did the appellate division agree with the Supreme Court? I'm sorry.
Yes, the appellate division
So
affirms.
6 judges have found it's not that clear so far, right?
I respectfully, Your Honor, sometimes 6 judges are wrong. Not these judges, of course. Thank you, Your Honors.
Or 7, we're never wrong. Thank you.
Depending on the ruling, right?
I'd like to move on to our cross appeal, and that concerns sufficiency of the rate and equal protection. It is not the case that the legislature can create a rate that says there'll be no payment for the nursing home care that we are providing through private providers such as appellants, such as plaintiffs. In addition, there are limits to how low they can go in relation to reimbursement, and that limit is set in Public Health Law 28073. 28073 says that reimbursement shall be reasonable and adequate to meet the costs which must be incurred by economically and efficiently operated facilities. That is an inherently factual question. The word reasonable is in there. The word adequate is in there. There was zero proof on summary judgment from the other side that the resulting rate would be reasonable and adequate, period. So this was a summary judgment motion. They did not shift their burden. We showed quite clearly how removal of residual equity would prevent our facilities and prevent these operators from paying for things like a new roof, social distancing.
Yeah, but isn't that an individual, isn't she right about that? That's each individual facility would, of course, have the opportunity to present your evidence as to why the rate is not reasonable in your case, as opposed to what you're doing here, and you correct me if I've misunderstood you, what you're doing here is across the board saying, obviously, if you've taken out this factor, you started out in your argument saying this is, if not the most crucial, exceptionally crucial factor because of the capital, the money involved, and if that's removed, then it must be unreasonable. I take that to be your argument. If it's removed, it is automatically unreasonable.
No, we're arguing each individually that by failing to pay us capital, our rate is insufficient. And we put in an individualized proof for a number of homes, several dozen homes. And again, the burden was not ours. The burden was on defendants here to show that our rates were, in the first instance, adequate to move the burden to us. Keep in mind, the first cause of action is an Article 78 cause of action. There was no record on return here. They could have easily put in all of the rate sheets for 100 homes and said, look, here's the rate, and we think that rate is adequate. They did not. Their summary judgment motion is 5 pages of text if you look at the motion itself, 19 if you look at the other documents that they put together. In those 19 pages, there is nothing said about what's reasonable and adequate. The appellate division said, well, because they had no discretion, because the legislature mandated it, and because the goal was to save money, then they showed it's reasonable and adequate. Non sequitur. Non-discretion has nothing to do with the factual question of what's reasonable and adequate. Cost savings has nothing to do whether it's factually reasonable and adequate. Equal protection. Bay Park does not say that in all cases and for all times, for-profits and non-for-profits are never similarly situated. That's what they're arguing here. Bay Park does not say that.
Did you sue the right entity or individual?
Yes. Yes, we did. Both the Director of Budget and the Department of Health are responsible for setting rates, period. And they're responsible, keep in mind.
Against the statutory choice of the legislature.
No, they are statutorily mandated by the legislature to make sure that our rates are reasonable and adequate. And capital reimbursement is a pure function of regulation. This goes back to the very beginning.
How isn't she correct, though, when she says, yes, but if they did exactly what you're requesting, that circumvents the amendment?
It doesn't.
The point of the amendment was to save money, and your argument is, no, the rates are unreasonable across the board, and therefore the money's got to be put back in.
We're not saying that no money could be saved. We're saying that there needs to be a balancing because the legislature's mandate in 28073 is sacrosanct. This court has repeatedly said that that is an important aspect of the prospective reimbursement regime. And keep in mind, we need to understand how Capital works. Just briefly, I see my time is up. The first substantive section of Public Health Law 2808, which is 2-A, sub A, says there shall be capital. It says, Commissioner, go and create regulations.
Didn't you have to start an individual process for each individual entity? Didn't you have to start an individual process where you would have an administrative determination of that individual entity's rates?
And
That then, if you lost, you could appeal?
And that's what we challenged here. Both individually, Article 78 and declaratory judgment, we sought both forms of relief, saying that our individual rates after removal were inadequate, and there was zero proof on summary judgment put in by defendants in this regard. They just said, we had to do it, this was to save money, so it's okay. That's not what 2807.3 says.
That's my confusion. I just may be misunderstanding the process. It would strike me you would need an administrative process where all of that is fleshed out, and then again, if they don't find in your favor, you can appeal that.
Oh, that's a
As
great...
opposed to just the amendment. Right?
That's a very important point, and one brought up by the amicus here. The 2807.3 prescribes 8 specific factual determinations to be made by the department. The department has now said, we don't have to write any of that down, we don't have to do any of that. If we think it's reasonable, that's enough. But no, for each one of our homes, 2807.3 says, for every single rate schedule submitted to the Division of Budget, you have to go through these 8 specific factual determinations and determine that the resulting rates are reasonable.
I thought they were actually saying the legislature thinks it's reasonable. I thought that's what they were saying. I may have
Well,
misunderstood.
but the legislature did not repeal 2807.3. That is still there. It's been there for over 50 years.
Yeah, agreed.
I see my time is up.
Thank you.
Next matter on the calendar is Alcantara Vianucci. Cantara, sorry, Vianucci.
May it please the court, Your Honor, Matthew Freemuth on behalf of the appellants. I'd like to reserve 3 minutes of my time, if I could, for rebuttal.
Yes.
I think it's important to put this case in the context of the other Court of Appeals decisions on residential treatment facilities. There was Gonzalez in 2018 that took up the question of whether DOCS was adequately providing housing assistance. There was Johnson that considered whether an RTF needed to be a home-like environment. And then there was McCurdy on the same day that held that persons on post-release supervision after 6 months can be held in residential treatment facilities pending their ability to locate SARA-compliant housing. Now here we are. What is a residential treatment facility? This appeal presents the question of whether Fishkill satisfies the requirements of a residential treatment facility, or whether DOCS has the discretion under the New York Penal Code to operate the Fishkill RTF without providing access to community-based programming and in a way that is largely indistinct.
Can I just
Counsel-
ask you,
From a
are you
prison.
arguing that Fishkill could never satisfy the RTF, or are you saying that as currently constituted, they couldn't?
We are saying as currently constituted, they do not, principally because they do not offer any community-based
So
programming.
suppose they made an attempt, and I can ask your adversary about whether they have or haven't, but suppose they made an attempt to place individuals who are in the RTF because they're there awaiting SARA-compliant housing, and they were not able to do so. And the record showed that there were, good faith efforts made. What then of your claim?
So if they made an attempt to locate or to provide community-based
They
programming
went out, they looked for opportunities,
in and around Fishkill, and they could not find any,
Yes.
then Fishkill would be a non-compliant RTF.
And so in that event, is your view that, DOCS would have to put them in another facility?
DOCS would need to put them in a facility that met the definition of an RTF where there were community-based programming.
Go ahead.
The notion of community-based programming is definitional to what an RTF is.
So what I'm wrestling with is this. I take it that your argument is a combination of the definitional section in 2.6 and the provisions in section 73, which relate to permission to leave and so forth, right?
Correct.
If there is an attempt made and it's not successful, it seems to me that reading those provisions to require docs to locate the facility in a different place or to move the individuals from that facility to another facility where those opportunities are available, I would think maybe we would want to look for some clearer instruction from the legislature, especially because it might be that with these individuals, it's difficult to place them in community opportunities. So can you help me with that?
Sure. I think, number one, I want to be clear that there is no record here that DOCS has ever made an attempt.
Yes.
And that is our fundamental.
I'm trying to understand your statutory argument, though.
Right. So look, section, or 2.6 is the definitional statute, right? It says, from our perspective, that an RTF must be in a community. That has to be a community where educational and employment opportunities are readily accessible.
And was that enacted before the SARA housing requirements were clearly in place?
It was enacted before the SARA housing requirements are in place.
So what I'm wrestling with is it clear that the legislature anticipated, you know, whatever set of challenges may attend this group? Or maybe your answer is it doesn't matter because the language is clear enough.
I don't think if my sort of timeline is right, when the RTFs were created and defined, I don't think SARA had been enacted, right? So they could not sort of anticipated it. But the fact that SARA has...
And with respect to the off-site opportunities, it also requires that there's a willingness of providers to have those opportunities made available to specific people, correct?
You would have to have a willingness of providers, but there's not specificity in the statute about who those providers are or whether other state agencies might provide.
Right, but it goes back to what Judge Halligan said. If they at least go out and they attempt to find engagement for, let's say, a specific person that's in the program, that they don't lump them all together, but they do actually exercise the discretion that it appears that they have, but they can't find a willing participant.
So, look, I think that raises, obviously, the question of if they don't have a willing participant, does this sort of definitionally meet the statutory requirements of an RTF?
And I thought you said it wouldn't.
I think, based on the definition of 2.6, you would have to say that in order to be an RTF, there has to be sort of community-based programming.
Now, that would apply, you're talking about, let's call them SARA, people subject to SARA, but this would apply to anyone in an RTF, right? Statutes don't distinguish.
The statutes do not distinguish.
So if you had someone who came and had a certain record and they just couldn't place them in Fishkill, that wouldn't be an RTF for this particular person in that RTF facility. It wouldn't qualify for that person.
I think whether a facility meets the definition of an RTF is not specific to an individual.
So what would it be?
Sorry.
Yeah, that's the question. So what would it be specific to?
It would be specific to the issue of whether there are or are not community-based programming available for the residents.
Yeah, what if there aren't enough? There are community-based programs. I think this is the question.
Yeah.
But you have 100, I think, SARA people at Fishkill right now. What if there are only 30?
I think our position would be that would meet the definitional requirement of an RTF.
Why?
Pursuant to Section 2.6, because there are community-based opportunities. Docs might then have discretion.
What percentage would it have to be? to meet the definition?
What percentage of individuals have to have access to that program for it
What
to meet?
percentage? You said we said 30%.
What brings you into
percentage?
compliance?
Yeah.
The existence of community-based opportunities for
10%.
some portion of the residents of
Would
the.
5 be enough to do it?
So you're hypothesizing a situation where there are community-based opportunities that only 5 RTF residents can take advantage of?
Yeah, I'm just trying to understand the scope of the requirement that you're
I
articulating.
think the scope of the requirement is that there must be some community-based opportunities. The statute doesn't specify how many or what percentage, but the record is
But
clear
you
here,
also
there are
have to-
none.
You also have to take into consideration who those individuals are. The programming's supposed to be made available for their reentry based on their circumstances. So these particular individuals in this program, they have some unique circumstances that have to be dealt with to satisfy the community part. But there's also an internal component where there's programming made available. So are you disputing that they've done nothing, or that the programming is partially compliant or not?
So I think our position is that with respect to the community-based aspect, they're statutorily non-compliant. And we also take the position that with respect to the programming offered within the facility, that also is non-compliant.
And why is that non-compliant?
The statute requires that the programming be specifically tailored, as Her Honor pointed out, to the individuals to meet their specific goals of rehabilitation and reentry into the community. And what the record below establishes here is that the programming offered really doesn't meet that requirement. There's not any specifically tailored programming. Most of the programming that's offered to RTF residents is programming that was available in their, the tail end of their determinant sentence, if you will, and so that they're failing, for the reasons we stated in our papers.
I got the impression that the programming taught budgeting, managing your financial resources, interviewing skills, and those all seem to be tailored to a reentry to the community. Is there something I'm missing?
I think the record is clear that there was nothing specifically tailored for individuals who were, facing challenges obtaining SARA-compliant housing or other challenges that those that particular class of persons might face.
So are you suggesting that in order for the programming to be sufficient, it has to meet certain minimum qualifications or have a certain minimum curriculum? Because it does, as Judge Canataro pointed out. There are things that do seem appropriate for people who are reentering society.
I think certainly one point is 73.3, which talks about specific programming being tailored to individuals' residents in the RTF. I think the record is clear that there is none of that.
Can we come back to your answer to Judge Canataro's question about the 5%? So 2.6 says that it defines an RTF as one where these opportunities are readily available for persons, okay? So how do you square that? I take it from your response to Judge Canataro, your position is that if the RTF makes a good faith effort, I appreciate your comment that there's nothing on the record about that, a good faith effort and is able to secure off-facility opportunities only for 5%, that suffices to meet the statutory obligation. Is that readily available? What work does that do?
I think it's a good point with respect to what the work is that the word readily does. I think it could be a question as to whether 5%, if they only had 5 positions open and 50 people in an RTF, whether that would would meet the requirement of
I took Judge
community-based.
Canataro, I don't want to put words in his mouth, but to mean 5 out of 100, which is the number there, and that's
Right,
what I was,
5%.
5%. Which
Right. I think there's a good argument that that would not meet the requirement of readily available for the
So
members.
if it doesn't meet the requirement, then are you saying they have to take them out of that facility, put them in another?
I think they have to move them to a facility. If it is an individual who belongs in an RTF, for example, an individual like, let's say, the petitioner in McCurdy, who is now post, release, 6 months, being held there beyond the 6-month requirement. The only statutory basis to hold that person is in a residential treatment facility. It must meet the definition of a residential treatment facility. Otherwise, you're talking about incarcerating a person who served their time and for which the state has no basis to hold.
And by your definition, treatment is inside and outside the facility. It has fit both components.
But what if they
Correct, Your Honor.
move them and they don't get placed in the next facility? They try, but no placement in the next. What happens then? They have to move them again?
I'm not sure what you mean by if they don't get placed
They
in the
don't get
next.
placed in a community environment for anything. It's still the same situation. They try, but, no, they're still in the RTF.
They must be placed in something that meets the definition of an
And they-
RTF, which.
There's no opportunities in the next one, so that doesn't qualify as an RTF for them either, then, right?
Again, we're sort of, I don't think whether this is an RTF for them or not is exactly the question,
Well,
because
it is
whether.
for the 5% that got placed, right?
Is your point that the right doesn't flow to the individual? In other words, that if I'm in an RTF and I don't get placed, that, I don't have a specific right, but when we look at whether the facility itself qualifies, we look as a general matter at the rights available?
Yeah, I mean, that is essentially the issue. It's a
And then we
definitional
would
issue
shut the
about the
RTF
facility.
down? So then the RTF would shut for everyone if it doesn't qualify as an RTF, if it's not an individual right? I don't understand that
If it
point.
doesn't qualify as an RTF, then persons who should be placed in an RTF, I think, again, persons after 6 months of their post-release supervision present the starkest example. Then
Do we have to answer any of those questions if the record, if we agreed that the record is devoid or lacks any information regarding what are the opportunities available near Fishkill? Or do you think the record is set on that? It's clear that there are no opportunities. It's not a question of whether or not they tried or not. There are just none.
I think the record is clear that there are no community-based opportunities at Fishkill within the meaning of 2.6.
So just to clarify, is your position that an RTF needs to make opportunities available for some percentage, maybe 5 is sufficient, maybe it's not, I don't know what the number might be or how we would identify it, and that the other individuals for whom the opportunities are not available can stay? Or is it your position that if I am at an RTF and there's no opportunity for me, docs must move me?
My position is is really a definitional position, which is to say, if I am an individual who should be in an RTF and I am at a facility where there are community-based programs available, then I'm at an RTF. Whether that specific community-based program that I'm talking
Even if
about
not
is
available
available
to
to
me.
me, I think is not this case, Your Honor.
Well, not,
I'm sorry. So just to go a little further on that point, then you're saying the universe is whether or not the RTF Fishkill in this case has in the vicinity, in its surrounding environs, possible opportunities for anyone who fits within that definition, even if everyone who is a SORA individual would not have, and therefore fits within the definition, but, right, they are listed and registered under SORA. even if none of them could find a placement, or Docs could not arrange a placement for them?
I think that's right, Your Honor.
Okay, so if all the others could find a placement, you would say it does or does not satisfy the definition, just to be clear?
I think if there is community-based programming available to some, readily available, then it meets the definition.
Even if it means someone who is a SORA registrant would not find a placement?
Well,
That's what I'm asking. I'm
Yeah.
sorry if I wasn't clear.
I think if there are a class
Yes.
for which there's nothing available,
Yes.
then as to that group of individuals, it doesn't meet the definition.
Thank you.
Good afternoon, Blair Greenwald on behalf of the respondents. I'd just to jump right in and answer the question that has been raised here about DOCS's efforts. Again, while not on this record, to my knowledge, DOCS has not made any specific efforts to secure outside employment opportunities because it believes it is not obligated to do so given the permissive language of the statute and given the fact that it doesn't have legal authority to secure third-party cooperation. It has focused the tools that it does have to get people out to community housing more quickly, which has successfully ended in a drastic reduction of the people at...
Your view is DOCS doesn't have to do anything other than what they've been doing here, the on-campus programming, but there is no community aspect to the RTF.
So there is a community aspect, and as the definition requires, that it be community-based in the sense of serving the general purpose of providing for rehabilitation and the goals of community reintegration. But that can be accomplished with programming inside and outside the facility, as the statute contemplates.
But 2.6 refers to a community where employment, educational, and training opportunities are readily available. You seem to be, I don't know, downplaying that part of the statutory language. I don't know if it's a command on DOCS, and you can argue that it's not a command to DOCS to seek out and secure those opportunities for the people in the RTF. But it certainly sounds like it's more than just, being near a community.
So while certainly there is a siting requirement, and that siting requirement does serve the purpose of removing at least one obstacle to DOCS being able to exercise its authority to secure outside opportunities, we also agree that the definition does use the term community-based as a fairly broad descriptor that refers to the RTF residents as being based on or being about the goals of rehabilitation and community reintegration. But
That's
it's
not what
very
it
normal.
says. I'm sorry, you're not even close. You have read out of the statute the language. This is operative language. Community-based residents in or near a community where the listed types of opportunities are readily available. Why would the legislature write? Why would you have that?
Right, so just to address both of those.
If it means within the confines of the facility.
Certainly,
Which that's how I understood your argument. As long as it's within the confines of the facility, if it's got rehabilitative goals, then that fits within this section. But then you wouldn't have any language about community.
So the definition requires that it be in or near a community where these opportunities are readily available as a general matter and not impossible due to lack of proximity to a community. So, a very isolated RTF that just would have absolutely no possibility of outside opportunities.
Then how could it be an RTF?
Right, so that would not be an RTF, and the reason why the legislature included this siting requirement was to remove that hurdle, right? Because they wanted to make sure that DOCS had the discretion to exercise its authority to provide outside opportunities.
Has DOCS made an effort to secure opportunities outside a facility at any RTF? Or only not at Fishkill?
So to my knowledge, not outside opportunities that are not docks facilities, and that is what petitioners are asking for here. So
I take docks, just to be clear, I take petitioners to be asking for docks to attempt to secure opportunities that are outside the property of the facility itself. You agree?
I think both
In the
that.
community.
I think, yes, in the community.
Yeah.
And
so- Go ahead.
I'm sorry. I just wanted to say that Docs has focused its efforts with the tools it has to get these people out to the community, and that is why now Fishkill has
Sorry,
an
what
RTF.
do you mean in terms of securing them, helping them secure
Sorry.
SARA-compliant housing?
Yes, SARA-compliant housing, which is why Fishkill now only has 19 RTF
Understood,
residents.
but I take it you're saying that at no, well, let me ask first, how many RTFs are there?
I'm sorry, I don't know the exact number. I think it's around 7.
Okay, and so your understanding is that at none of those facilities designated as RTFs has Docs or is Docs attempting to secure any opportunities in the community to work or have some employment training opportunity while they're in the RTF, setting aside the SARA-compliant housing?
That's correct, Your Honor. Fishkill, I will note that Fishkill is certainly the largest RTF, so that is why the focus of this.
So I take it Docs doesn't know what the challenges or opportunities might be should it choose to pursue that, since it hasn't done so?
Not as a, factual matter as of right now, but the important point here is that we're interpreting the statute and what the legislature would have
So
anticipated.
just to be clear, before identifying a facility as an RTF, no one makes an assessment whether or not it could comply with the community-based opportunities requirement?
It does, Your Honor. So the RTFs have to be near a community where.
So there's an assessment that goes on before it is so labeled? That was my question.
Yes.
As opposed to we'll label it an RTF, then we'll figure it out.
Right, so an RTF on a remote island would not fit the definition here.
So I realize none of this is in the record, but I just want to be sure that you're sure about what you've told us. My understanding is that there are RTFs, there's 2 RTFs in New York City. Is that wrong?
There are 2 RTFs where New York City is designated as sufficiently close to be considered the community.
Located in New York City, located within the 5 boroughs. Is that not right?
I think the 2 closest RTFs to New York City are Fishkill and Queensboro.
And
that can-
where's Queensboro?
Queensboro is actually further from New York City than Fishkill is.
And so there's nothing in the city itself, you think?
Not that has any substantial
RTF.
portion of individuals, at least.
Okay.
I want to ask, I'm sorry, Chief.
No, go ahead.
I want to ask a related question to what the chief was just asking you. My understanding as well was that Fishkill was the RTF most closely located to New York City, putting it in my mind in the greater New York City metropolitan area. Now, I don't know how many, you said there might be 7 other RTFs. I'm wondering whether you have a sense, because I'm worried that if there aren't sufficient community-based opportunities around Fishkill, which is the closest to the major metropolitan city, that the other RTFs are almost by default going to offer even less of those community resources. So my question is, do you have a sense that if Fishkill wasn't compliant because there weren't sufficient number of community-based opportunities, or they couldn't secure them, would there be another RTF where there are more community-based opportunities or greater opportunities to secure them?
So I think Your Honor's concern about having opportunities available nearby is not so much related to Fishkill's distance from New York City, because the Beacon, Poughkeepsie around Fishkill, those are also used to meet the geographic siting requirement. What we are concerned with here is that it both meet that definition of being near enough a community that, as a general matter, has opportunities available, and the legislature's understanding that for certain populations of the RTF at different times, it may be impossible for docs to secure such opportunities. And correction law section.
Are you saying it just has to be near a community, but no actual opportunities have to be made available?
So there have to be opportunities that are generally available, as the
Generally
definition.
available to whom?
To people on community release or eligible for community release. And this shows the legislature's aspirational goals of allowing docs To the
And what's
extent,
DOC's responsibility with respect to said availability?
so DOCS's responsibility is to secure these opportunities regardless of their location. So that is
What does that mean?
that is in section 73, 2.
I think
And
one of the
it-
things you said at the very beginning, when you were going really, really fast, so I may have missed it, was that DOCS has no legal authority to work with outside third parties.
Sorry, no legal authority to force private parties generally to cooperate.
Oh, but you're not saying you don't have an obligation to try. You just can't compel them.
Well, we also believe that there's no language in the statute that obligates DOCS to try, and the legislature knows how to do that. In section 2015, which the court looked at in matter of Gonzalez, that talks about DOCS shall assist
So
these
it's correct
individuals.
that you're focusing on the location of the RTF near a community where opportunities are generally available. As long as that's done, DOCS doesn't have to lift one finger to even try to help even one person. Is that what you're saying?
So that is correct, but that's because the legislature wanted to make sure that DOCS's authority wasn't just entirely a nullity just because of this lack of
So then
proximity
what
to a
does section 73, because you had mentioned it before, 2 mean when it says the department shall, it doesn't say may, not could, decide on its own, discretionary, shall be responsible for securing appropriate education, on-the-job training, and employment for incarcerated individuals transferred to RTFs. You're saying that that training doesn't have to be community-based? Is that the way you read that, just to clarify what you think the point is of 73-2?
So it's community-based only in the sense that it's directed toward these goals of rehabilitation and reintegration.
Okay, so then
It doesn't-
what's the point of the second sentence? The department
Right.
also shall supervise such incarcerated individuals during their participation activities outside any such facilities and at all times while they are outside any such facilities.
Exactly. So section
You're
2.
securing the opportunities, and you got to supervise them if they're outside the facility.
So section 2 imposes these fairly burdensome obligations on DOCS to secure the opportunities and to supervise them at all times while outside. And to compensate for those burdensome obligations, the legislature made permissive the fact that DOCS may secure these opportunities outside. And the permissive
Where's the
language
permissive? That's what I'm saying. Where is it permissive?
in 72.6 and in 72.1. So the two places where they talk about what individuals being able to go outside, in section 73.1, it says that such person may be allowed to go outside the facility. That is regarding DOCS's authority to allow them outside. And 72.6 talks about an incarcerated individual of an RTF may be permitted to leave such facility in accordance with the provisions of
But
section
isn't
72.
that essentially making sure there is discretion available to DOCS for appropriate individuals, not just having discretion that you don't utilize?
That broad discretionary language is both entirely in line with what the legislature normally does when granting agencies authority to design and operate programs, and particularly in the context of corrections, where the department has.
No, that is clearly understood. DOCS doesn't have to let just anybody out into a program after an individual assessment where they find that they would be inappropriate to participate in a particular program because of either a danger to the community, something in their background, or something that occurred on the facility. They don't just have to let them out, but what you're suggesting is they don't ever have to let anyone participate in anything or supervise them anywhere.
That is correct according to the language of the statute. And what Your Honor mentions about, a particular individual not being appropriate, that actually is a separate provision of 73. That is in 73.4, where DOCS may suspend such program for such an individual.
I want to make sure I understand what you're telling us DOCS's process is. So what I took you to say is that in the course of selecting an RTF site, the docks does assess whether there are opportunities to go outside the facility into the community and engage in employment or training. Is that right?
So yes, but I want to be clear that the general analysis is that it be near a community. And any,
Those are very different. Is there any, I understand near a community, that's a question of proximity, but is there any analysis that DOCS does of whether there are, in fact, potential opportunities out there for individuals to leave the facility and work or be trained? If you know.
in the sense that the community, as a general matter, would have, jobs available.
So DOCS is assuming because there are different kinds of commercial, stores, whatever, operations, that there might be opportunities.
Essentially, yes. So DOCS doesn't do a targeted search to make sure that the particular individuals at the RTF at that time will be able to access or, be able to secure particular opportunities in that community at that time. And that, again, makes sense with what the legislature intended here, because it's, not clear at any one time what type of population is going to be in the RTF, what type of opportunities DOCS will be able to secure. And DOCS is held to a more onerous standard of actually securing those opportunities.
I just want to get back to 73-2 for a second. Is it your position here that DOCS complies with its obligations under 73-2 by providing education, on-the-job training, and employment entirely at the facility and not in the community?
Yes, as long as it meets all of the other requirements under Section 73.
Thank you.
Just a few points to address fairly quickly. A common thread through many of the questions was the difficulties that DOCS may face in locating or identifying community-based programs. With all due respect, that is not a basis, difficulty or not, to shirk what is a statutory requirement, which is to provide RTF residents or define an RTF as something that includes community-based programming. And also, there is no record to support that either DOCS has attempted to do so or that it was difficult.
But would it be
Is
enough
that really a
to-
statutory requirement? I mean, 72 and 73 say residents may be allowed to leave the facility. So shouldn't we just let the legislature amend that to must, if that's really what they meant?
I think you can read 72 and 73 and the use of the word may entirely consistently with the definitional requirement that an RTF include community-based programming.
But my
72
understanding is that you're saying must in terms of must have a placement, not must make reasonable efforts, right?
There must be community-based opportunities, correct.
So would it be enough to say they have to make all reasonable efforts to secure community-based opportunities, or no?
I don't think that would be enough.
Why not? Why isn't
Because-
the effort enough?
Because the Section 2.6 says that those community-based opportunities must be readily available.
But what about the
those community-
component that DOCS doesn't have control over, which is private industry?
If the community-based opportunities are not readily available, then it doesn't meet the statutory definition of an RTF.
So do they close the facility?
They can't label it an RTF, because at that point, it is essentially a general confinement facility that they've labeled an RTF.
But if
There must be a
five
difference
people
between
in
those
that
two.
RTF can't be placed because there just are no opportunities for them, they have to close the RTF for everyone?
No, I think that gets to the question of whether the opportunities are readily available at that facility.
There's also authority, I thought, that DOCS has to say that some individual person is not appropriate to participate in the program. And presumably, if there is an individual, but tell me if you have a different view, an individual who, for whatever reason, is someone for whom DOCS cannot find a placement, that isn't there an argument they would fit within that exception?
Yeah, I mean, I think that gets to the issue of DOCS's discretion, right? We don't dispute that DOCS has some discretion around the circumstances and conditions
So you're not
that
saying-
an individual can be in the community, right? That's effectively what 73 establishes.
So therefore, it seems to me that it's not the case that every individual at an RTF would have to, in fact, be placed for it to qualify as an RTF, or do you?
Correct, I agree with that. I agree with that.
What you take, is it correct that what you take exception to, and what it appears that the respondent acknowledged, that they don't have any obligation and they're not making available across the board? Is that the problem?
That is exactly the core issue. They cannot exercise discretion to such an extent as they have done that effectively redefines an RTF into something that's not recognizable under the statute.
Thank you.
Thank you.
Last case on today's calendar is People v. Baez.
Good afternoon, Your Honors. Harold Ferguson for Appellant Melvin Baez. We would request 2 minutes for rebuttal.
Yes.
Contrary to the Appellate Division's decision, the people did not establish by legally sufficient evidence that the item that Officer Lynn allegedly recovered from the ground at the scene of Mr. Baez's arrest was the exact item that criminalist Cesario received and tested at the lab. The bottom line was, Officer Lynn indicated that she recovered a badly torn open bag that was so badly damaged that the white substance that was within it was pouring out. As a result, she took that single bag, put it within a latex glove, tied it shut, and later delivered it to an office at the 113th Precinct. But at the 113th Precinct, all she did was take that single latex glove and put it in an unsealed envelope. Although there is
So is there evidence that what was put in the envelope was somehow in a different condition than that which it was when she put it in there?
Absolutely, Your Honor, because when Officer Lewis comes and retrieves the envelope, what he finds within it is not a single latex glove, but 2 items.
Does he say it's not in the condition that it was?
He says there is within the envelope, there is a latex glove and another bag. Officer Lynn did not put 2 items in that envelope.
And where is that item in between? In between when she puts the item in the envelope and when the next person picks it up?
It is it's an unsubstantiated period of time between the time Officer Lynn leaves the precinct.
And the envelope is where?
Is on a desk where there is supposedly some anonymous officer who's supposed to safeguard evidence. But there is no evidence in this record that in any way did Officer Lynn.
So were they required to call that evidence officer?
What they needed was at least some type of indication that Officer Lynn spoke to that officer, told that officer what was there, and to safeguard that evidence. There is nothing in this record to indicate anything regarding the safety protocols in that office, who had access to that office. And when Officer Lewis comes hours later to the office, he does not talk about any security protocols in that office and does not mention that there is a single other officer in that office. So there is a period of time where we don't know who is supervising this. And what we do know is that when Officer Lewis picks up the envelope.
So when you're establishing chain of custody, you have to call every single solitary person from the time they took it out of the car, from the time they retrieved it, every step in between. Anyone they encountered they must call?
No, Your Honor, that's, Julian and Connolly do not require that. But what you have in this situation is that in Connolly, it talks about when there is an undisclosed person who had access to it, and which we have here, and that there is a period of time in which there is nothing that describes who is supervising this. And most importantly, when Officer Lewis comes to the precinct, what he finds within the envelope is two distinct items.
Before he opens the envelope, Officer Lewis goes to the desk to take the envelope.
That's correct.
And he finds it exactly where Officer Lynn said it would be, doesn't he?
Yes, he does, but what Officer Lynn said she put in the envelope is not what Officer Lewis finds in the envelope. What Officer Lewis finds in the envelope is two items, the plastic bag and the latex glove.
So then what matters for your argument is these inconsistencies in the testimony, that not whether or not one knows, was there a person there, where the envelope was placed, what's the name of that person, do they need to testify? It's these inconsistencies that suggest some other problems in this chain of custody?
Absolutely, Your Honor, that there was the possibility of tampering and that we do have...
There were no inconsistencies, and we still didn't know all the things you've already pointed to. Would you still have an argument on the chain of custody?
Could you repeat that, Your Honor?
Sorry. If there were no inconsistencies in the officer's descriptions, and I think her name is Ocasio or Osorio, whatever the criminalist identifies, but we still didn't know about the placement of the envelope, whether or not someone was in that room, whether or not someone else entered that room and touched that envelope. If we didn't know those things, but there weren't the inconsistencies that you've very clearly pointed out in the briefing, is there still an argument about the chain of custody?
Yes, there is, because there is nothing in this record that indicate that what should have been sent to the lab for testing is the latex glove. That was sealed as a singular item, and there is only a single bag that's supposed to be within it. There is no description of Officer Lynn of having 45 glassine bags or anything else. And
I think Judge Rivera was asking you a different, sorry, right here, it was asking you a different question. That is, suppose what we had is a single bag, there's no discrepancy at the site of the arrest about what was collected. It's described one way with this, weight that, the officer estimates that the same weight that the criminalist weighs, that the condition of the bag is exactly fine, that the sticker carries through. The only defect is it was placed on a desk in an envelope. We don't know who was there. We don't know how much time elapsed. That's all. If we just had that, would that be a chain of custody problem?
I don't think it would be a chain of custody problem because there still would be an assurance of the identity of the item. But what you have here is you don't have Officer Lewis testifying that I removed the latex glove, that I opened the latex glove, I took out an item from the latex glove and weighed it. Instead, what he talks about is the other item, and the latex glove disappears. Not in the exhibit, the photographic exhibit that is presented as evidence at the trial. And so you have this Officer Lewis testifying about, an Officer Lewis who, let's be honest, had committed perjury on multiple times in this particular case.
Let me ask you a little bit different twist on that hypothetical. Let's say you had a great chain of custody here. You have the same testimony. I took this thing, I put it in the glove, I put it in this envelope, I sealed the envelope, I signed it, I handed it to the next officer. That officer testifies I took it from the first officer, I took it, I carried it to the safe, I locked the safe, I got it back, I took it to the lab says I received it from that officer, same envelope, it's sealed, I open it up, and now it has the things that you've described it having in. Do you have a problem or no?
I'm not sure what you're talking about.
So same facts about
Right.
what's in that envelope, but now you have a perfect chain of custody.
If you have a perfect chain of custody, there's no issue here. We wouldn't be here, and Judge Wilson would never have granted me leave in this case. But that's not what you have.
Don't count on that.
You have something that she's testified to putting in that bag that doesn't match what comes out of that bag, right? In my hypothetical.
Okay, then you do have a problem. And that's partly what you have here, is that the description is that it is a badly damaged bag that was recovered by Officer Lynn.
No, I understand. My question, though, is if you have the chain, but you have the same facts on either end, you have the officer testifying this is what I put in there, but it doesn't match what they took out in the lab. But the chain is perfect.
Something happened. We don't know what happened. It can't be a perfect chain of custody if the item
But
has
she could have made a
somehow been
mistake.
transfixed.
I made a mistake in what I thought I put in the bag.
Right, there could have been a reporting error on one end or the other with respect to the description, right?
So what happened?
Well, it's not if in a situation, if it's simply a reporting error, but this is not what you have. This is not a reporting error case. This is a case in which the item doesn't match. What the criminalist received was an intact bag that had no damage to it.
It's even more, troublesome, nettlesome than that, because the latex glove is not part of what was recovered from the defendant. The latex glove was something that Officer Lynn decided needed to be used at the scene at the time she picked up the envelope, because she thought, I guess, things were coming out of it. So with respect to this notion of reporting errors, it seems as if it's possible that someone decided to remove the latex glove because that was not part of the evidence that was collected from the defendant, and either failed to report that they discarded it or didn't think that they had to do that.
Your Honor, but that's not what happened here. When Officer Lewis says that what he found inside the envelope was the latex glove, which had been tied shut by Officer Lynn.
Yeah.
Officer Lewis does not say that I removed the latex glove, I untied it, took something out of that. What he says is there's a latex glove in the envelope and also this bag that is badly damaged and 45 glassine bags. Those are two separate and distinct things. If Officer Lewis had testified, I removed the bag, I untied it, I pulled those items
Counsel,
out of it, but he didn't.
That would suggest to me that if there's a latex glove and a bag that has another bag inside of it with 45 smaller bags inside of that, a lot of bags. But if Officer Lewis testified that he saw these two things, that suggests to me that maybe Officer Lynn, when she previously had the evidence, took those things out of the latex glove. She might have left the latex glove there, but she removed them.
That's not her testimony. Her testimony is she put the tied latex glove in the envelope. That is the sole thing that she did in that office. She did not testify that she removed anything from it, that she had tied it shut because the bag was so badly damaged that everything was pouring out.
And that's a serious inconsistency in the record. I'm just not sure how it goes to the chain of custody, because everything is where it is supposed to be and being cataloged along the way.
Your Honor, but what you have is one item cannot become two items, and that's what you have here. Officer Lynn put a singular item into the envelope, a latex glove that was tied shut. What Officer Lewis finds in the bag is a latex glove and these bags. Those are two distinct differences, and those indicates that somewhere between the time that Officer Lynn put the latex glove into the envelope, someone else put a bag into that envelope as well.
I thought Officer Lewis also testified that differently about the contents at different points in time.
Oh, absolutely, Your Honor. I mean,
it's not just the bags.
No.
It's also the actual criminal substance.
I mean,
right?
At times, he originally, in the felony complaint, this case, again, began through perjury. The felony complaint said Officer Lewis signed under penalty of perjury that he recovered 2 twist bags containing 4 ounces of cocaine from Mr. Baez's person. That's what started this case. Jurisdiction was obtained over my client through perjury. At the grand jury, he again commits perjury, where he says that he recovered 2 bags from Mr. Baez, each containing 9 grams of cocaine. Only until we get to the suppression hearing does Officer Lynn even come to the forefront, where it indicates that, oh, by the way, he recovered nothing at the scene of the arrest. It was Officer Lynn who recovered something. And then he talks about that his voucher doesn't match up. He says he weighed things, and then he sent it to the police lab. But the problem with it is there's no damaged bag at the criminalist. Osorio doesn't find a damaged bag. She finds an intact bag. So something happened. Someone repackaged something.
The bag was admitted into evidence at trial, right?
A bag was admitted into evidence.
A bag.
A bag was admitted into evidence, but what Criminal Osorio testified to was that what she received was an intact bag that had no tears or anything in it. So therefore, even what Officer Lynn had said from the beginning, such a badly damaged bag that everything was pouring out, you couldn't have waited because it was so badly torn open.
You agree, though, don't you, that we have bags on bags on bags? There's a larger bag with another bag, and then 45 glassine envelopes within that bag. So
that's what Officer Lewis testifies to, but that's not what Officer Lynn, who's the recovering officer, testifies to. She refers to a single bag that contained a white substance.
And what about Ocasio's assessment of what is actually in the bag that Ocasio analyzed?
She says
How does it differ from the testimony?
That she found 5.35 grams of cocaine, which she described as loose solid material. At different points, Officer Lewis refers to it as in rock form, and sometimes it's in rock and powder form. There are so many different versions of what has occurred in this case that it is inconceivable to me that someone can say that the item that was allegedly recovered at the scene is the item that Criminalist Osorio tested. And because of that, there is these defects in the chain of custody as to both the identity as well as the opportunities to tamper with it. Someone put another bag into that envelope. That establishes under Connolly and under Julian that this isn't the same item that was recovered by Officer Lynn, and therefore Mr. Baez's conviction should be overturned and the case dismissed. Thank you, Your Honors.
Good afternoon, Your Honors. Chris Bluricosla for the Office of Melinda Katz, the Queens County DA for Respondent. Just to address the point about the glove at the precinct with the bags in it, Officer Lewis testified, this is on page, I'm looking at my adversary's appendix, page A221. He was asked by Mr. Baez on cross-examination, Mr. Baez represented himself, and he said, question, you said you recovered 2 twist bags. What did you recover? How many bags? Was it separated? Was it 1? Was it 5, 10? And the answer was when it first initially fell on the southwest corner, the little baggie was inside the big baggie, so that's how it was vouchered. Question, was 1 bag? Answer, I took it apart. So the contact he had with that bag is back at the precinct. Lynn left it at the precinct, told him where she left it on his desk. He goes to the precinct, and she left it in a narcotics envelope. He goes to the precinct and finds it in the exact same place. That testimony shows that he took it out of the bag and separated it. He also testified he photographed it. The photograph in our appendix.
But what about Officer Lynn saying she put 1 bag in the glove?
Right.
And what about Officer Lynn saying the bag was damaged, and Lewis saying the bag was damaged, and the criminalist saying there was no damaged bag?
Well, the criminalist said she didn't see any holes in the bag, but if you look at the prosecutor's opening and
I think she says it was intact. I think there was a lot of examination about that.
I don't recall if she used the word intact. I know she said she didn't see any holes in the bag, but when the prosecutor described the bag, which was in evidence during his opening and closing, he said it had...
A bag was in evidence, right?
No, both bags were in evidence.
Well, we don't know how many bags there were, right?
Oh, we know exactly how many bags there were. Lynn, when when Lynn testified, she explained, and I can give you the page cite to this. This is Lynn at A308. She testified, I didn't count it, I just put it inside the glove, so she didn't take it apart.
Lynn at 357, no, the envelope, the plastic security envelope that I received was not ripped in any way. Are there any holes in the bags? Which bags? Any of the bags? No.
Sorry, that's
found
a
350. The bags ripped in any way. There were no rips. I mean, 357. She's unequivocal.
This is a 357, you said?
Yeah.
But also, let me just go through the summation, the opening point I wanted to make.
Summation's not evidence as far as I was taught.
No, but the summation is discussing evidence that is in evidence, and without objection, the prosecutor said there's scuff marks on it, tears, rips. Mr. Baez didn't object, and Mr. Baez had a lot to say during trial.
You and I have a very different view of evidence, I guess, which is that if the prosecutor says something that is not in evidence and there's not an objection, that makes it in evidence.
I don't think we have a different view of evidence. What I'm saying is that the prosecutor's remarks were not objected to. If
So
that
what?
bag was not described
So
that
what?
way, if the bag didn't look
So
like that,
what?
somebody would have objected. His silence speaks volumes
This is a
about
pro
it.
se litigant, and you're saying that we should then treat this as evidence? This is really
This
like
is a
beyond
pro se
pale.
litigant. This is a pro se litigant who, if he went to law school, would probably make a great lawyer because he had a lot to say. He
But
was
what we
never
do
silent.
have-
He objected
what
to
we-
everything.
So why don't you get back to my question, which is we have sworn testimony from the officers, both of them, that the bags were torn, that material was falling out of them. They had to be put in a latex glove to secure the evidence. And what gets to the criminalist? There are no torn bags, no rips, no nothing. Isn't that
The
troubling you?
criminalist said that she didn't, no, it's not a problem because all the voucher numbers match up. It's the same voucher number. So what about that? That means nothing, that it had the same narcotics number, the same voucher number,
That means-
same bag number. It was sealed when it got there. Maybe she just made a mistake. Maybe she didn't see it. All the numbers match up. You can't discount that evidence
I'm
based
sorry,
on
what
her.
are all the numbers that match up? Let's do the little breadcrumbs. What are all the numbers that match up?
The first is the invoice number. That's on the voucher that lists the evidence. The second number is what's called the PETS narcotics number. That's on the narcotics envelope. Then the voucher and the envelope and the evidence are put inside another bag that's got a third number on it. All three of those numbers match up. Everything was sealed and signed when Osorio received it. She testified to that, and she said she resealed it. At trial, they both testified that, yeah, these are the same numbers, that's my name. She testified to her name on the report.
So then you understand that to mean they both made mistakes in their descriptions?
Osorio may have made a
Because
mistake.
whatever went through, despite the fact that each of them are saying, or all three of them are saying something different, the numbers match up, regardless of the fact that at some point in time, the prosecutor failed to put into evidence that there's a point in time when it appears no one is supervising the envelope.
Well, I mean, I don't think we have to put in that person. You know, I mean, look at Hawkins. The evidence was
What do you
left
do
alone.
with all these discrepancies?
with the
It
discre-
doesn't trouble your
I-
office that you have these officers who don't even know what they're picking up, when they picked it up, how it gets it in one place and ends up looking completely different in the other place?
Oh, no, I'm not saying our office doesn't encourage accuracy in police paperwork. Sometimes it doesn't happen. This paperwork is at a model of clarity,
discouraging
admittedly. But again, that goes to weight, doesn't go to the chain of custody, doesn't go to admissibility. Just to go back for a minute, Officer Lynn testified it was one bag. Then we have the testimony from Officer Lewis about finding the glove that Lynn said that she left in the office in the exact place where she said she left it. Testimony says he took it apart, he photographed it, it's clearly two bags. Right. So any discrepancy there is explainable. Lynn didn't look at it when she first recovered it. Why? It was spilling out. She isn't going to take it apart there in the street. But
And he was also wrong that he thought he had recovered it from Mr. Baez, just to clarify.
no, they call that perjury. I think that's just.
No. You understand and recognize that's a discrepancy.
No,
You're trying
no,
to
that's
make
not a
it seem-
discrepancy at
It's not
all.
a discrepancy that he thought he recovered it, and you have another officer who says, I recovered it.
She picked it up off the floor, but they're partners recovering the same evidence. He vouched it. If anything, his role in the process is more important than hers. Just picking it up off the floor is not how evidence is
So it's a
recovered. You got to vouch
misunderstanding
for
in
it too.
it's a misunderstanding in terminology?
Yeah, I'd just say maybe he spoke in a broad fashion about the fact that he recovered it along with his partner.
What about twist bags, 2 twist bags with 4 ounces of cocaine? And I checked on Google, 4 ounces of cocaine is about like 120 grams.
It's different, yeah.
It's a
but
lot.
The common way criminal complaints are written up in the 5 boroughs is that the ADA or the paralegal writes them up. Officers don't write them up. I don't know how it's done in other counties. He obviously didn't read through this carefully enough before he signed it.
So that's just bad record keeping on his part?
That's bad record keeping on everybody's part. It was a mistake that should have been made.
Because he just doesn't know what it is?
Excuse me?
He doesn't know what it is?
I'm
He
not
doesn't
following.
know what it is on the record keeping and this discrepancy, doesn't know what it is he's identifying in the record?
No, he did identify it on the record by his name and by the numbers that he assigned to it. There, I think he just didn't read the complaint accurately. And that led to the discrepancy. I think what's more important here is that this evidence was kept in police custody at all times. It wasn't like the evidence in Hawkins that was left just left alone in a room.
So to go to Judge Garcia's question to your adversary, is it your view that if the chain is established really very cleanly, that no discrepancy would be problematic, no matter how severe?
I mean, that's basically what this court said in Conley. I mean, reporting errors in paperwork don't change the essential nature of what's recovered. There's nothing on this record that the actual evidence itself changed in any way.
What if it was a different substance?
Such as?
Instead of what was recovered, it was a different type of drug altogether.
A different type of drug, like
Yes.
from cocaine to heroin, then that's a problem. Yeah, no,
Okay,
that
so
would be
there
a
are
problem.
some discrepancies that would give rise.
But not in paperwork. I'm talking about the actual substance.
No, I'm talking about the paperwork.
No.
So no matter what it is, no matter how varying the descriptions are, that's irrelevant to a chain of custody inquiry, period.
Well, it's not irrelevant. It does go to weight. It doesn't go
Yes,
to
I
admissibility.
understand.
So, and that's where it begins and ends. That's Conley.
But you've
That's
got a
black letter law.
problem. You've got a problem in testimony. You've established what went in the bag here, went through the process and ended up here. One, I don't understand the drugs because you don't know what it is till you test it. But you have something that goes on here, comes out the end here. You think it's the same thing. It just doesn't match the description of the person who put it in the input side. To me, that seems like a testimonial problem, not a chain of custody problem, right? There's a problem with the testimony.
I mean, it was described, I mean, look, it was cocaine. That's how it was recovered. That's how it was tested. In the voucher, it was described as rock. Powder was left out. They made a big deal about that at trial. But the criminalist testified that, yeah, it was a loose, solid material, which would include rock and powder. You know, just because he left out the powder description doesn't mean it's a different substance. Again, these are reporting errors. There was no claim ever made that what was entered into evidence, that it changed in any way, that it went from a solid to a liquid,
So
or from
do
a
you
this to a that.
agree with Judge Garcia? It's not a chain of custody issue, but it's a weight consideration.
Basically, it's a weight consideration. And all the discrepancies.
And what does that mean? What does that mean? That the court has to decide, I just don't believe you?
No, I mean.
When the court is hearing the testimonies, deciding, I think that's incredible, I don't believe you.
If the court just doesn't
Is that what you mean?
believe-
I just want
No. It becomes a jury question at that point.
But
Then it
again,
can
the
be submitted
weight
to the
is
jury.
is the issue of the weight. The
Right.
credibility determination or something else. That's what I'm asking.
Right.
Yeah, I
you
mean,
say it
it's
goes
not
to
so
the
much the
weight.
credibility of only the testimony, but also the inconsistencies, how to resolve them, and finally deciding the case. As far as admissibility goes, I don't know if your question is, do you take those into consideration in terms of the weight
What's the
analysis?
value
of
I'm trying
determining
to
admissibility?
appreciate the acquittal of the other counts.
Right.
So that's why I'm asking, is it a credibility issue or it's something else? Because perhaps that might explain the actual verdict.
Yeah, I mean, I think it's something else that goes to the verdict. For example, he was acquitted of the possession charge, so
Yeah.
maybe the judge accounted for the fact that the 45 glass scenes weren't reported. That would go to the third-degree possession
Okay.
count because, intent to sell. He was acquitted of the tampering charge. So maybe the fact that that wasn't recorded in the voucher, I don't know for a fact. Maybe that entered into the judge's logic. Maybe, threw him a freebie and said, okay, here, fine, it wasn't recorded, I'll give you the acquittal on that.
Talking about the judge's fact finder, not the judge's
Yeah, this is a bench trial, right?
law.
Right, it's a bench trial.
Yeah.
I mean, as far as admissibility goes, this is actually more than enough. This is more than you had in Hawkins,
When you had in,
Hawkins at 11 New York
Yes,
3rd. The evidence wasn't even left alone for a long period of time. The arrest or the incident occurred at 11:21 or so on February 4th of 2014. It's brought to the precinct. It's not clear when the exact time Lynn drops it off at the precinct, but
it's a similar question to Judge Halligan's, but I think slightly different. What if the testimony is consistent that what went into, let's stay with the glove that then goes in the envelope, is in rock form? Not in a powder or smooth powder, just rock form. But when the criminalist opens it, there are no rocks. Do you say that goes also to the weight?
you mean it's in powder form instead of rock
Yes,
form?
as opposed to the crystals, the rocks, yes.
I mean, it probably would go to weight because it could be crushed during the transportation process. I mean, if there's some explanation for it, I think it'll be okay. But, again, we're talking about the form of the actual substance now. We're not talking about reporting errors, which consistently courts have held only go to weight.
And if the criminalist said, if it was a rock, it would not in transport have ended up with this kind of powdery residue.
If the criminalist said
that what you just described as the explanation was not possible. You still say that still all goes to the weight.
I think it would go to the weight, because that would be pretty strange testimony, that a rock could not go into powder. I mean, cocaine can easily crumble. I mean, that's, you
Well,
could have...
let's
different-
say it starts as powder and ends up as rock.
Or the other way, yeah.
Yeah, I mean, I think what goes to admissibility would be more of a more drastic change than that, like in color, or a real change, like from, say, a solid to a liquid or something, where it's clearly, it can't be the same thing. But for rock cocaine to go to powder, and then you're saying it's not the same thing, that's just not the way it is.
So some change conditions, you're saying, can go to admissibility and not weight?
Some change conditions, but I'd say it has to be pretty drastic. I don't think it's just rock to powder. I mean, I think that can be discounted. I mean, if the criminalist said that, fine, but, it's up to the judge to make that ultimate determination as to admissibility.
Yes, so then when you are talking about weight, you say it's not about admissibility, it goes to the weight. It's about a credibility determination. I believe you or I don't believe you. I believe that the criminalist says that's what they found, or I don't.
I think weight that goes to more of what the jury does, that the fact finder does, not in the process of determining whether
But again,
something's admissible.
that's what I was trying to get to, what you mean by weight. I'm left with, it
that's-
must be a
that's what I mean by
credibility
it.
determination.
You
Unless
know,
the
and-
criminalist said, no, there's an explanation. This change is certainly possible.
In terms of your example with the rock into powder?
Or the powder to rock, either way.
I mean, she could say that. I don't think that's the kind of change that cases talk about where it becomes inadmissible. Something going from rock to powder form. If there's like a change in color, I mean, that would be quite odd if there was a change again from solid to liquid or something like that.
And you would say then that doesn't go to the weight?
That would go more to admissibility, like a drastic
Because it's
change
simply
in what the
impossible?
substance is.
Because it's simply impossible?
Because it just wouldn't make sense unless explained. If it can be explained, that's another thing. If it changes color because of the testing process, let's say, and the
And
criminal
you say
testifies to
here, there
that.
is an explanation, in your
For
view.
all the inconsistencies, yeah.
Yes.
Yeah, I mean, Lynn says one bag, he took it apart and saw two. Criminalist says, yeah, I saw the 45 bags in there, which is what he saw at the precinct. In the arrest report, he's charged with sale. That's another thing they brought up, but he was never formally charged with sale. He was
And
only charged with
if what
possession.
Lynn got was, everything is the same, except what Lynn got was some white material that turned out to be cocaine in a pickle jar, that's weight. Has the label on it.
That'd be extremely odd, Judge, and, would deserve a very thorough inquiry. It's not what happened here. I've never heard of that happening, and I hope that never happens, because that would be pretty bad. But yeah, I mean, a case like that kind of arose in, I think the case was Dunham v. Melly, where somebody brought blood to a lab, right? Gave it to somebody they didn't identify or couldn't identify. And then the person at the lab put a label on it. And then the person that tested said, well, the vial doesn't have the label. The label was on the box instead. And the third department, it was a 1961 case, the third department ruled that there wasn't enough to meet the chain of custody because of this mislabeling. So, that predates Conley. I don't know anymore if that might go to more of a weight question or an admissibility question, because it's still still argues the same vial of blood. Your question of a pickle jar, it's, I hope that never happens. Me too. That's how I'll answer that. I hope we never get a case like that, because that's a much more difficult argument. But this case, it's pretty simple. It's always in police custody. You got the voucher numbers. You have 3 witnesses, not just Officer Lewis testifying to the chain. There's no evidence of tampering. There's speculation of tampering. But what he's saying about the bags, nobody planted the bag. That's explainable by the testimony and the fact that Lewis took everything apart at the precinct. So for all those reasons, the chain was made out, everything else goes to weight, and we ask you to affirm the appellate division's decision.
Thank you.
Your Honors, it's not simply paperwork errors. Look at Officer Lewis's grand jury testimony when he says there's no mention of Officer Lynn at all. He says he personally recovered the 2 items from the ground. Each one contains multiple Ziploc bags and crack cocaine in the form of small rocks, a white substance, and powder. And what no one and my adversary has not been able to dispute is there are 2 items in the envelope. Officer Lynn only put 1 item in the envelope. She put in the envelope a Tide latex glove. She did not put in a Tide latex glove and a bunch of other bags. Officer Lewis does not testify, I removed the latex glove, I cut it open, I removed it, and then weighed those items. His testimony is what I received or was on that desk in that envelope was 2 items. 1, a latex glove, which disappears and is never seen again. He does not testify he opened it or did anything to it. He did not photograph it. But what he also says is he recovered a 2nd item, which is the bags that are in question. That showed up between the time Officer Lynn put the stuff in the envelope, the latex glove, and when hours later, Officer Lewis came to the precinct. He finds 2 items in that. That establishes that what Officer Lynn recovered is not what was sent to Criminalist Azario for testing.
Let's say, I'm sorry to go back and hate to beat this more, but same facts here. Officer Lynn takes the envelope, seals it, boom, you don't see that, but she comes in, she puts it on the desk. There's a video camera there, and it's watching this 24/7. The next officer comes in, takes it on video camera, brings it to the lab on video camera, the lab opens it, dumps it out, and it's different things than what she says she put in the envelope. What's the end result of that?
Her testimony would have been false at that point because
Or she misremembered it, or she made a mistake. And isn't that what you mean by weight? Because depending on how strong the chain of custody is, depends on what happened here, right? So if your chain of custody is bulletproof, that it's this thing that was put in the envelope that got to the lab, then a mistake has to be made at this end in terms of what she thinks she put in that envelope, what she remembers she put in that envelope, what she wrote down she put in that envelope. So isn't that what we're really getting at here? How firm is the chain of custody? So how much does that indicate that she made a mistake versus there was tampering somewhere along the
She did not make a mistake. Her testimony was crystal clear throughout her testimony that she recovered a single bag that was torn from the ground, that was so badly damaged that she needed to put it into a latex glove.
How long after that event was she testifying? How long after she recovered the drugs did she testify in court?
It was, it was a long period of time afterwards, but she has, and Officer Lewis also testifies that she put the bag into the latex glove. So it's not simply Officer Lynn testifying that she put the bag into the latex glove. Officer Lewis also testified that she put the bag into the latex glove. So therefore, when she then testifies that she put that into the envelope, and then Officer Lewis comes hours later and finds 2 items in that,
but
that came from somewhere else.
Same testimony, we'd have to assume they made a mistake, right?
I don't believe they made a mistake.
No, but in mine, where the whole thing's on video after.
If it was on video, then you would have the proof that she misremembered. Here, you have both officers testifying what Officer Lynn did at the arrest scene, and that was to put the bag into the latex glove and to tie it shut. But what's in the envelope is 2 separate and distinct items. If he had testified that he removed the latex glove, opened it, we'd be in a different situation, but he doesn't. The latex glove disappears, never photographed, and by the way, Criminalist Azario does not identify they had the photograph that Officer Lewis took. The people never asked Criminalist Azario, is this what you received? They didn't ask her that question. There is a gap. There are gaps in the chain of custody. This evidence was tampered with, and Mr. Baez's conviction should be overturned. Thank you, Your Honors. Thank you. And I'll see you next month on Search and Seizure Day. Have a great day, Your Honors. Have a good day.